Good morning. My name is Felicia Orth.
This
We're
meeting is
on
being transcribed and summarized.
day 3 of the hearing in EIB 25-23. This is the Clean Transportation Fuel Program hearing. We had just a little bit of technical difficulties at the end of the day yesterday. Let's see, Ms. Gerson for CCAE had conducted 5 minutes of cross-examination when we had to move on to Mr. Nasco, who completed his cross-examination on behalf of Growth Energy. Then we had a bit of questioning by Member Trujillo to get us to the end of the day. So we're going to return to Ms. Gerson unless someone wants to identify a preliminary matter this morning. Any preliminary matters? No. All right. Terrific. Ms. Gerson?
Thank you. Good morning. And because I imagine folks didn't hear me yesterday when I introduced myself and greeted you, I want to introduce myself as Sarah Gerson, attorney representing Coalition for Clean Affordable Energy in this docket. And thank you for this opportunity, hearing officer Orth, chair, and board members. Now, let's return to where we were yesterday evening in my conversation with Dr. Murphy. Dr. Murphy, do you recall yesterday that I had asked you to explain what you were referring to in your testimony when you mentioned what you called EV requirements in Oregon? And in your answer, you mentioned Advanced Clean Cars 2 as an example of one such rule.
Yes, that's correct.
To clarify, the Advanced Clean Cars rule doesn't mandate sales of electric vehicles, but instead mandates sales of zero emission vehicles, correct?
Hold
Sorry.
on. Yes, Ms. Sona?
Can you hear me? Oh, okay. I will get a new microphone for where I'm sitting. Objection.
We are having some feedback. It may be that someone is on a laptop that isn't muted. I see Ms. Nixon has a laptop, and that gentleman there, please mute them. Also, while I'm thinking about it, turn off your phones. Okay, go ahead, Ms. Sona.
We established 2 matters in prior testimony with these witnesses. One for Dr. Murphy, that the scope of his testimony is not on New Mexico specifics. And second, that this calls for a legal conclusion about the law.
All right, thank you. So, Dr. Murphy, I'm sure you can walk that line between speaking as someone familiar with these programs and speaking as a lawyer. As to the other objection, though, Ms. Gerson, do you remember our discussion that way? Asking Dr. Murphy about specific implementation that would be specific to New Mexico is outside the scope of his testimony.
Thank you, hearing officer. I don't have any questions for Mr. Murphy that are about New Mexico specific analysis or rules.
Okay. Oh, speak up, Ms. Gerson, again.
Thank you, Madam Hearing Officer. Do you want me to respond to Council Sona's objection, or should I proceed?
If you rephrase the question, let me hear it again. And again, I will try not to bug you, but we need you to keep your voice up.
Thank you. Dr. Murphy, I am trying to clarify your testimony where you refer to rules such as Advanced Clean Cars 2 as electric vehicle mandates by asking you to confirm that the Advanced Clean Cars 2 rule does not mandate sales of electric vehicles, but instead mandates sales of zero emission vehicles.
So that's correct. The vast majority of zero emission vehicles on the road today are electric. And for the purposes of that study in Oregon, because we were interested in the emissions, the modeling treated them equivalent. So I probably used the term an EV mandate as shorthand, but you are correct on the specifics.
Okay. So just to make this as clear as possible, this is an example of a technology neutral performance standard, correct?
It's an interesting question. I have not thought of it. I haven't considered that question. I would say that yes, if you're setting the standard at zero tailpipe emissions, then there are multiple technologies, and in that way, it's technology neutral.
Thank you. Switching gears, in your written testimony, you address the complexity of assessing the carbon intensity of fuels produced from crop-based feedstocks, correct?
Yes.
And would you agree that because of the complexities of land use change modeling, there is more uncertainty in the estimates of the carbon intensity of biofuels than in the carbon intensity assessments for petroleum fuels?
Yes, I'd say that's generally true.
And similarly, would you agree that biofuels have carbon intensity estimates that are more uncertain than electricity?
Generally speaking, yes.
And can you think of any other fuel types whose carbon intensity analysis involves more uncertainty than biofuels?
Well, there's only a handful of fuel types out there. I would say there are some really novel advanced technologies where the production process is not well understood that would have greater uncertainty.
Okay, can you give me an example, or
I
if
mean,
not, that's fine.
I've seen proposals for all kinds of exotic molecules, dimethyl ether, dimethylfuran, or dimethyl ether, or I would say DME or DMF. I don't think it's important that you spell the chemical name. So yes, there are some advanced technologies for really exotic stuff that is still largely in the lab or very small scale demonstrations. Those are probably more uncertain because we know less about them. But generally speaking, there is uncertainty. There's a lot of uncertainty in the assessment of biofuels.
Okay. And in your written testimony and your testimony on the stand at this hearing, you've discussed how in 2015, the California Air Resources Board adopted the indirect land use change values that an MED is proposing to adopt.
Ms. Gerson, speak up again, please.
Thank you. You have testified about the process that the California Air Resources Board used to adopt the indirect land use change values that an MED is proposing to adopt in the New Mexico rule, right?
Yes.
And I think yesterday you confirmed in conversation with Growth Energy's council that staff completed their analysis supporting those values in 2014. Is that correct?
No, I think it was completed in 2015 or perhaps in 2016 before the adoption. I was not directly part of that process. One of my colleagues at UC Davis was a reviewer on that. Those values were adopted into the rule in 2016. I can't imagine the analysis was completed in 2014.
Okay. Can you confirm that the data that the staff relied on was from 2004?
I would have to go back and reread the modeling reports for that. I don't know.
Okay. Is it fair to say that by its nature, any analysis of indirect land use change will reflect the situation in the snapshot in time that the data is from?
Yes, ILUC values are going to change over time as markets evolve, as technologies evolve, as impacts of climate change occur.
And can you explain in a little bit more detail why ILUC values change over time?
So, ILUC analysis is basically attempting to answer the question, uh, if we're using agricultural products that previously or otherwise would have gone into food, and instead we're using them for biofuels, what is replacing them? Where's the food that they would have provided coming from? And what are the environmental impacts of replacing that? So the answer to that question changes over time, depending on market conditions, depending on technology, depending on geopolitical conditions. It is absolutely reasonable to expect that ILUC values are going to change.
And would you agree that all else being equal, increasing volumes of production of biofuels will tend to increase the carbon impacts of land use change for that biofuel production on the margin?
Um, I think I think that's a strong argument, and it's likely. I don't think anybody has done any analysis to confirm one way or another, but I think there's certainly possible, or probably likely, yes.
And do you think it's fair to say that the ILUC factors California developed um, reflect market conditions and expectations that did not contemplate the high volumes of biofuels in use today?
Yeah, that's absolutely correct. In fact, I'm pretty sure I discussed that in my written testimony. I was clear that the values that CARB used 10 years ago reflected, a good faith effort to use the tools at the time, but they need to be updated. The challenge is there isn't a manifestly superior alternative that's come out, in part because of the lack of investment into research and modeling that approaches the question in the way that regulatory agencies need to approach the question.
I see. Yes, I think the exact language from your written testimony is that, quote, it is likely that existing GTAP based ILUC assessments, including the ones used in the California LCFS, underestimate ILUC impacts rather than overestimate them. Does that sound right to you?
Yes.
And are there any additional reasons why you believe that, in addition to what you've already discussed today?
Having spent many years reading studies on the topic, you can find published values both above and below. And the EPA intermodal comparison document that I referenced in my testimony does a good job of looking into that. There are a number of models that claim to be able to answer this question. On this for corn ethanol, which is one of the major areas where ILUC is sort of highly salient to the questions we're asking today, the uncertainty is a bit less. But for lipid-based fuels, so biomass-based diesel, if you look at the range of uncertainty, most of the other estimates tend to be higher than CARB's values.
Thank you. I appreciate that. And that completes my examination that I have prepared for Dr. Murphy.
Thank you.
Shall I move on to questions for Mr. Vaughn?
Yes.
Thank you. Good morning, Mr. Vaughn.
Good morning, Ms. Gerson.
I have questions for you on just one topic that you address on page 33 of your written testimony. So please turn to page 33 and let me know when you're there.
I'm there.
Thank you. So the last paragraph on this page addresses the department's proposal for fuel supply equipment credits, correct?
That's correct.
And this is essentially a credit generation opportunity for developers who install infrastructure that can dispense low carbon fuels, right?
Could you restate the question one more time? I want to make sure I heard that correctly.
Well, let me just ask you instead to state in your own words what the fuel supply equipment credits are.
So the fuel supply equipment credits are essentially an opportunity to solve the sort of chicken and egg problem that exists. I'll use electricity as an example. So you can earn fuel supply equipment credits for installing an electric vehicle charger, for example, among other fuels. And those are designed to ensure that there is an opportunity to install that infrastructure while mitigating some of the risks that are associated with establishing that infrastructure. They essentially, as I believe Dr. Rosso testified yesterday, they offer credits for the times that the equipment is not essentially dispensing fuel.
Thank you. That's helpful background. And in your testimony, you provide the example of a station that can supply renewable naphtha earning these credits, correct?
It would be based on the carbon intensity of the naphtha, the renewable naphtha. And that would have to be compared to whether or not it would still be credit generating by the next decadal statutory target. So in 2030, if renewable naphtha was 20% below the 2018 baseline, then theoretically, yes, it could earn fuel supply equipment credits for the dispensation of renewable naphtha.
Okay. And in your testimony, you describe renewable naphtha as a drop-in fuel compatible with gasoline engines. And I'd like to clarify what you mean by drop-in fuel. That means that the renewable naphtha is so chemically similar to petroleum gasoline that it can be used in equipment that was designed for gasoline, correct?
Essentially, yes.
And isn't it correct that gas stations would not need to install additional infrastructure or modify their current equipment in order to dispense renewable naphtha?
Well, there would be more than likely with renewable naphtha, there would be some type of blending wall, just like there is with biodiesel, for example. So I'm not familiar with whether or not the sort of ancillary equipment that's used to store or transport or dispense renewable naphtha. I'm not sure if those are exactly the same, so I don't know if there would be changes necessarily to the equipment as compared to uh, a, the typical gasoline fuel supply equipment, for example.
Okay. And what's the basis of your opinion that there's a blend wall for renewable naphtha?
My understanding of that blend wall comes from, excuse me, I believe that was something that I learned in my conversations with H.F. Sinclair.
H.F. Sinclair. Okay. Um, so, are you, um, do you have any further information about the um, ancillary equipment that would be needed to be installed in order to dispense renewable naphtha?
Objection, Madam Hearing Officer. This has been asked and answered. He said no.
If he said no, I'll be happy to move on.
Thank you.
Um, okay. So under the proposed rule, there's a limited pool of credits available for fuel supply equipment, correct?
Objection, Madam Hearing Officer. Scope of the rule is not Mr. Vaughn's testimony. He's testifying to public engagement.
Okay, thank you. Mr. Vaughn, is there another witness who would speak to that?
There is, Ms. Porchert.
Thank you.
All right. Well, that is a fantastic transition to my questions for Ms. Borchert then.
All right, before you move there, let me ask everyone, if you're using a term that might be unfamiliar, for example, to the court reporter or the interpreters or the general public, like naphtha, if you would spell it, please. Thank you.
I can spell naphtha.
Yes.
Yeah. NAPTHA.
Thank you very much. All right, we'll move now to Ms. Borchert.
Good morning, Ms. Oh, sorry. Please let me know when I should proceed.
With apologies for correcting Mr. Vaughn's spelling, it's NAPHTHA.
Thank you. Go ahead, Ms. Gerson.
Thank you. Good morning, Ms. Borchert.
Good morning.
So let's start by finishing the conversation about fuel supply equipment credits that I began with Mr. Vaughn. Can you please confirm that under the proposed rule, there is a limited pool of credits available for fuel supply equipment?
Yes.
And have you examined the operational capacity of fuel supply equipment for renewable naphtha or other renewable combustion fuels to evaluate how many of these fueling stations it would take to consume that entire pool of credits?
No, we haven't.
Thank you. Switching to a different topic, you testify about the proposed rules related to book and claim accounting, correct?
Yes.
So I would like to clarify how your proposed book and claim rules would work in practice by walking through an example of how they would apply to a company that dispenses compressed natural gas, which is also known as CNG, for fuel in New Mexico. So are you prepared to answer a line of questions like that?
That depends on how hypothetical you get.
All right, well, let's dive in and see. A CNG supplier can buy the methane molecules that they dispense at a fueling station from one supplier and the environmental attributes of biomethane from a different supplier, correct?
I don't think so.
You don't think so? So, your understanding of the rule is that in order to claim the environmental attributes of, say, renewable landfill gas um, from a landfill in Kansas, the CNG supplier would need to purchase both the energy content, the molecules of methane from that landfill, as well as the environmental attributes of that landfill gas?
Yes, my understanding is that you're purchasing the fuel with its environmental attributes.
Okay, so your intention in this rule is to not allow what's often known as unbundled transactions where you separate out the molecules from the renewable energy attributes, and biomethane suppliers sell their methane to one customer and the environmental attributes to another.
My understanding is that that the book and claim component is about allowing a fuel to be purchased with its environmental attributes, and then have that fuel enter a distribution system, and then demonstrate that an equal amount of fuel is then available to dispense in the CNG station in New Mexico for a vehicle that uses CNG. CNG, we're good? Okay. Compressed natural gas.
Is it the department's intention to apply rules for book and claim accounting for biomethane that are similar to the rules applied in the California low carbon fuel standard?
I am not familiar with how book and claim works in the low carbon fuel standard in California.
Okay. Okay, so yeah, your goal is not necessarily consistency with those rules.
Objection, Madam Hearing Officer. The question is mischaracterizing the evidence in an intimidating manner.
All right, Ms. Gerson, the stray comment afterward, Ms. Borchert gave you her answer.
Okay, I'm sorry. I guess it's probably clear enough on the record, so I can move on. Let's see. And if I were to represent to you that the way book and claim is practiced in other jurisdictions is significantly different from what you described as the intent of your rule today on the stand, do you think it would be appropriate to issue guidance to the regulated community that tells them that they can only claim the environmental attributes of fuels that they actually purchase?
Could you repeat the question?
So the I might need to give you a bit of information that hopefully you can accept as true for the sake of conversation.
Objection, Madam Hearing Officer. To provide that amount of information, we haven't heard it yet, but preemptively, that's not in the record. If council can point to where this is in the record, otherwise that's too big of a hypothetical for purposes of the hearing.
All right, Ms. Gerson, if you could point to where it's in the record, that would be great. As you ask your question, go ahead.
Dr. Leskowski described the operation of book and claim in her testimony that has not been admitted into evidence yet. If that is not sufficient, I can find a way to rephrase the question.
Oh, okay, so ask the question again, please.
So would you intend to issue guidance to the regulated community on New Mexico's intended requirement to only allow parties to use the environmental attributes of fuels that they actually purchase and not allow the types of unbundled transactions that we were just discussing?
I think you're confusing my answer.
Perhaps can you clarify for me?
It is my understanding that the book and claim in our rules would allow, for example, a manufacturer of, let's say, let me think about a good fuel. It could be compressed natural gas. Let's say if in the process of an anaerobic digester that has, and I believe they do, engines that help clean the gas, renewable natural gas, before it gets injected into a pipeline. And they, within their regional, I forget what it's called, the regional area that supplies them electricity, if they were to buy a REC, actually, yeah, so they're using electricity to pump the fuel, to clean it before it goes into an aerobic digester, and they don't have on-site electricity, but they want to pair the use of their electricity with a renewable energy credit for the electricity within their distribution area, and I'd have to look up what that actual term is, then that environmental attribute of the electricity is not directly on site and can be transferred to that facility, as to that anaerobic digester, as it is making the fuel, as it is producing the fuel. So that fuel itself has a component of book and claim energy associated with it. And I think that's different than the question that you asked.
Thank you. That is different from the question I asked, because I'm not asking about electricity. I'm asking specifically about biomethane, which is a fuel that is not transferred through the electricity grid, right? So it's in your rule. The definition of book and claim accounting refers to common transportation and distribution systems, correct?
Yes.
And for biomethane, that common transportation and distribution system would be a natural gas pipeline, correct?
Yes.
So, can you explain to me how a CNG supplier, someone who operates a CNG fueling station, could take advantage of book and claim accounting with biomethane that is injected into a natural gas pipeline?
Well, if we go back to that same anaerobic digester, fuel is produced. It's assigned a CI value based on where the CI is produced and how it's produced, right? They'd have to use a temporary table. They'd have to also apply for an alternative fuel pathway. So let's assume they've been given a CI. Then when that biomethane is produced at an anaerobic digester, then the recipient of that fuel would report in our system that they have purchased that bundle of fuel. It has a certain CI value based on its alternative fuel pathway, and they're describing to us in our reporting system how that fuel is consumed in New Mexico.
Okay. And you were aware, correct, that when somebody buys methane from a methane supplier that is, at some distance away from them across a pipeline system, they need to and want that methane delivered to them. They need to contract for delivery of biomethane and pay the pipeline operator, correct?
Yes.
And so in
My
the example,
understanding.
thank you. And so in the example you just described, would the would the CNG company that is generating fuel credits need to contract for delivery of that biomethane from where it's captured, be it a farm or landfill or whatever, and injected into the pipeline? Would they need to contract for delivery of that biomethane to the station via with the pipeline operator?
I don't believe so. That's that intent of having it put in. So I believe that the purchase contract would need to demonstrate that it is put into the pipeline. That requirement for deliverability is exactly what book and claim is meant to not require.
Okay.
Well, let me just be clear on deliverability, as in the molecules that were put into the network of natural gas pipelines. The pipeline operator does not need to demonstrate to New Mexico that molecule went from the farm to the dispensing station, but I imagine the dispensing station needs to demonstrate that molecule that got put in one place is connected in the network that ends up at the dispensing station.
And so Would a CNG operator be able to demonstrate that connection if the biomethane was injected into a gas pipeline in Maine?
I'm sorry, I did not hear the last word you said.
The state of Maine.
The state of Maine. I believe so.
Would they be able to demonstrate that connection if the biomethane was injected into a gas pipeline in Brazil?
No.
And can you point me to the language in the rule that would limit them from claiming the environmental attributes of biomethane that is injected into a pipeline in Brazil?
The section is 201C, and all of those are the conditions for book and claim accounting for liquid, for gaseous or liquid transportation fuel. And it describes needing the need to have the environmental attributes. And if the part 2, if the gaseous transportation fuel or liquid transportation fuel is injected into the transportation pipeline of a local fuel distribution company, establish and maintain an agreement with a local distribution company. I'm sorry, I was reading that way too fast. Okay, let me go back to establish and maintain an agreement with that local distribution company, along with any other purchaser of the gaseous transportation fuel or liquid transportation fuel, that only the fuel reporting entity shall make any claims of the gaseous transportation fuel or liquid transportation fuel's environmental attributes reported through book and claim accounting. So the fact that there is no connection in the pipeline between Brazil and any dispensing station in New Mexico, that would mean that that would not work.
Can you point me to the specific language within subsection C2 that requires a physical connection? I missed that.
Into the transportation pipeline.
Okay, so you read transportation pipeline to mean the same transportation pipeline that delivers fuel to the consumer in New Mexico.
Yes.
Okay, that is, thank you for answering that question. Can you confirm, so we've been spending a lot of time discussing biomethane, but can you confirm that your proposed rules would apply the same book and claim accounting rules to liquid biofuels like renewable diesel, as they're the same as what the rules that apply for biomethane.
I couldn't hear that last word you said. Could you please repeat it? Oh,
I'm sorry.
biomethane. Was that the last word?
Yes.
Biomethane. There's an added component when it comes to any liquid fuel that the a lot of the biofuels have air pollution reduction characteristics when they're burned in vehicles in New Mexico. And so that needs to be considered as well, whether it's really a one-to-one offset.
And can you tell me where in your rules that is considered?
I don't think it is considered in our rules. I was questioned about that yesterday, and then I spent some time last night thinking about it. So I think we need to think about. I'd never thought about this application to renewable diesel, but indeed, as some of the later witnesses will testify, there is an environmental benefit to having that fuel consumed in vehicles in New Mexico. And so that's one of the essential differences between how biomethane would be consumed in vehicles rather than a renewable diesel.
Okay. And can you confirm that none of the clean fuel programs in other states allow liquid fuels like renewable diesel to use book and claim accounting?
I believe that's true, but I'm not positive.
Okay, thank you. I have some more questions on the rule language for book and claim, and I'd like you to specifically look at what you've proposed for 201 C4, and let me know if I get this right when I say that that proposed language would allow regulated entities to take advantage of book and claim accounting for gaseous or liquid fuels, quote, only if it is not reported in any other program in a way that would cause the environmental attribute being claimed more than once.
The 200s are the domain of my colleague, Dr. Rosso, so I would like you to talk to her.
Those are questions for Dr. Rosso. Well, there are the questions I had related to page 15 of your testimony, so I might ask you or no. All right, I have a general question. Can you explain how the verification process is different from the certification process?
Ms. Gerson, please speak up again.
Can you explain, just as a general matter, how the verification process is different from the certification process?
Can you point to me where in the rules you're talking about certification?
I think certification of carbon intensity.
So that would be in the 200s.
Okay, so that's another question for Dr. Rosso.
Yes.
Um, all right. And so all other questions about how you intend to avoid double counting of environmental attributes, those are all for Dr. Rosso.
I think they are sprinkled throughout the rule, so you need to ask a question specific to which part of the rule you're referring to.
All right. Yeah, I think these all relate to 201C. So let me thank you for your time, Ms. Borchert, and greet Dr. Rosso to try to help me understand some of these issues we've been discussing. Good morning, Dr. Rosso. Are you ready to answer some questions about double counting?
Good morning, Ms. Gerson.
So I don't know if you've been following along and have 201C in front of you. If not, just, let me know when you're there.
205. One moment.
Sure.
I have 201C in front of me.
Thank you. So is it fair to say that the intent of 201C4 is to prevent double counting of environmental attributes?
Yes.
And then
But
the
I
next.
can expand a little bit if you'd
Yes,
like.
yes.
On the
Please
intent of
go ahead.
201C4, the intent was to prevent double counting of environmental attributes in multiple programs that allow claiming environmental attributes, such as other clean fuel programs or cap and invest programs in states that have those, while also allowing providers of transportation fuels to claim those fuels for certain types of programs where the environmental attributes are not the same, such as the Renewable Fuel Standard and federal biofuel tax credits.
Okay. Thank you. Can you please clarify if the intent is to also disallow double counting with voluntary programs in addition to regulatory programs?
I think that might depend on the type of voluntary program. I'm not sure what type of voluntary program you're talking about.
So let's say a voluntary offset program, like if I fly on Delta Airlines and when I check out, I click a box that says I want to offset the carbon impact of my flight by giving them $3 to purchase offsets. Would you intend to prohibit double counting with that type of voluntary program?
Not that particular type, no.
Okay. And you mentioned tax credits. I have another specific follow-up question to drill into potential double counting there. Would you intend to exclude the use of biomethane environmental attributes that are also used to claim federal clean hydrogen production tax credits?
I would think we would want to avoid double counting with those only in that we would want to see them retired for the same volume of hydrogen produced.
And in an example where, say, a hydrogen producer purchases environmental attributes from landfill gas to take advantage to generate tax credits for clean hydrogen production. And they use that hydrogen to make fertilizer, not supply transportation fuels. Would you permit a regulated entity in New Mexico to use the environmental attributes of that same biomethane to generate credits in your clean fuel program?
I think
Madam Hearing Officer,
Ms. Sona.
the number of hypotheticals that counsel is presenting to these witnesses, I'm not sure how this is helpful to the board. Essentially, it's asking the witnesses to predetermine answers of what they're going to do rather than asking them why the rule was written in a certain way. There's a difference.
Okay, Ms. Gerson?
Well, I am asking the witness to apply the language of the rules to foreseeable situations. And if that is a speculative determination that is ambiguous under the rules, I think it's important for the board to understand that the rules don't anticipate and deal with these situations.
All right, thank
Ma-
you. Yeah, Ms. Sona.
To explain this further, these hypotheticals, they're not foreseeable matters as presented by counsel that are in the record. If she can point to where this is in the record to address it, then it would be an appropriate question. However, we're not at the rebuttal phase in which we're applying the perspectives of other parties to the department's rule.
All right, I guess I haven't, though, heard her pose a hypothetical that was, penguins on Mars kind of hypothetical. Flying on a plane, for example, seemed like a reasonable question to pose. I would just caution Dr. Rasso, if the hypothetical posed to you is so speculative that you wouldn't see a reasonable way to apply the rule as it's written, just go ahead and say that. Go ahead, Ms. Gerson.
Dr. Rasso, do you need me to repeat the question?
if you could, that would be great. Thank you.
So the question was basically if you have environmental attributes that are used to claim hydrogen production tax credits, and that hydrogen is not being used as a transportation fuel in New Mexico, but rather, say, to make fertilizer in Pennsylvania, would your rules allow regulated entities in New Mexico to use the same environmental attributes from the same biomethane to generate credits in your clean fuel program?
In order for the biomethane to be claimed as process energy in production of another fuel, as would be the case in this hypothetical, they would have to be associated with an approved alternative fuel pathway. And there are requirements for alternative fuel pathways showing that they deliver fuel to New Mexico. So I think that leads the answer to be that the energy that was used to produce it must result in transportation fuel delivered to New Mexico.
Okay. Yeah, so similar to what Ms. Borchert was saying, that that hypothetical I just discussed, that would be precluded by your requirement that entities purchase both the environmental attributes and the energy in the biomethane itself in a bundled transaction. Am I understanding you correctly?
It's a slightly different mechanism than Ms. Borchert was discussing, because we're talking now about using biomethane and its associated environmental attributes as process energy to produce another transportation fuel. But it's a similar concept.
Okay. And are you Section 201 C5 requires environmental attributes to be retired in a tracking program recognized by the department, right?
That's correct.
And are you aware that California's low carbon fuel standard does not require environmental attributes to be retired in any sort of registry?
No, I'm not aware of that.
Okay, so how do you plan to verify that parties aren't using the same environmental attributes in both New Mexico and California's clean fuel program?
I think that we're requiring that they show that the fuel be deliverable to New Mexico and purchased with the environmental attributes, and that would preclude that from occurring.
Okay. Thank you. Well, thank you, Dr. Rasso. I had thought I would have that conversation with Dr. Borcher, and I am putting you through double time. So let me just thank you for the time you've had so far, and now turn you to page 21 of your testimony.
Hold on, Ms. Gerson. Mr. Noyes.
Thank you, Madam Hearing Officer Graham Noyes for the SAF producers. I'd like to move to strike the final series of questions there, because I think it was based on an incorrect hypothetical that doesn't follow California law.
All right. I think a better way to do this would be better to resolve this later or through this objection. Ms. Sona, let me get Ms. Sona's opinion.
Madam Hearing Officer, Mr. Noy's concern is going to the point that I'm trying to raise, that we're being asked to presume that the questions themselves Ms. Gerson is presenting are fact. The manner in which they're being asked, although I'm not consistently objecting to them, is extremely prejudicial, because she's essentially putting her opinion as counsel out there and asking the witness to agree or disagree for a policy speculation that's entirely lacking full contextual information. And so this is not a line of questioning that is helpful. And as the witnesses shared with Ms. Gerson, it in fact is not helpful. And so I would agree that striking this would be an appropriate approach. If Ms. Gerson would like to use her remaining time to ask the questions in an appropriate manner, then she can recover those topics.
All right, thank you. Mr. Noyes, if you would expand on your objection as well.
First of all, I'd second Ms. Sona's summary. And secondly, I would, the premise in terms of the statement of not retiring the RECs for purposes of compliance in California, I believe by my interpretation is an incorrect view of the law in California. And so I'd like to put that on the record and resolve it in the appropriate manner.
Sorry, Ms. Gerson, would you like to respond?
Well, I don't think that this is the appropriate opportunity for me to argue my disagreement with Mr. Noyes, who I am afraid is mischaracterizing California law. But to address the matter that's actually at hand here, I asked the witness if she was aware of a policy in California. She said she was not. I did not ask any other questions about interpreting the law in California, but rather a very relevant question, which is within her expertise, which is how do you plan to verify that there is no double counting of environmental attributes in the New Mexico and California programs? She gave her informed opinion of that, and I think it would not be in the board's interest as it makes an informed decision on this case to strike the answer to that question.
All right, so I'm not going to strike it at this point. Mr. Noyes, I know your cross-examination of the panel is coming up, and I would definitely encourage you to ask the questions that you believe would have been more appropriate here. And I know that this won't be the last time we talk about this. So
Thank you, Madam Hearing Officer.
thank you. Ms. Gerson, you are about halfway through, even allowing a few minutes for the objection, you're about halfway through your examination with Dr. Rasso. So let me encourage you to move on.
Thank you. So on Monday, you testified about the department's engagement with the California Air Resources Board on its ongoing efforts to improve how California accounts for indirect land use change. Do you recall that?
I recall saying that the NMED looks forward to participating in that process.
Okay. Are you aware, and if you're not aware, that's just let me know, that the California Air Resources Board recently adopted additional provisions related to land use change impacts from biofuels?
Objection, Madam Hearing Officer. Again, this is presuming that evidence exists that's not in the record. Whether or not Dr. Rasso is aware of it, it's outside the scope of her testimony for this specific point. It's calling for speculation that just is not helpful here.
Ms. Gerson, speculation usually is not helpful to the board. Do you intend to put in the evidence you would be relying on here?
We can address this in rebuttal. I think that it's kind of a classic cross-examination, appropriate line of questions to ask witnesses what they are and are not aware of, and just refrain from follow-ups if a matter is outside of their awareness. But it sounds like the hearing officer is eager for me to move on, and that's fine.
I am, yeah, because at some point it needs to be, as they say, connected up. So, yeah, go ahead. You have about 10 minutes left.
Okay. In your oral presentation, you also explained that the department intends to include avoided carbon dioxide emissions from flaring when it evaluates carbon intensity of certain biomethane sources, correct?
That's correct. Though I should caution that I believe I was talking about the temporary table fuel pathways. Alternative fuel pathway applications will be evaluated on a case-by-case basis.
Okay. Is it also your intention to include avoided carbon dioxide emissions from flaring in that case-by-case analysis?
I think that would be appropriate, depending on the application and the exact situation. As I said, it's a case-by-case analysis.
And are you aware that when the clean fuel programs in other states certify carbon intensity values of biomethane, that none of the other programs provide credit for avoided carbon dioxide emissions from flaring?
I'm not aware of that.
Okay. So let's talk more about that case-by-case application process. And this time focus specifically on avoided methane crediting. So is it your intention that if you look at an application and determine that biomethane would have entered the atmosphere in a business as usual scenario, that you would award what's called avoided methane credits?
Madam Hearing Officer,
Ms. Sona.
perhaps Dr. Rasso knows the answer to this question, but I believe it goes to the issue of asking for speculation when she's already testified that this is case by case.
All right, Ms. Gerson, are you honoring the distinction that Dr. Rasso drew between the calculation from the temporary table and the case-by-case analysis?
Yes, I'd like to build the record on how she intends to conduct the case-by-case analysis.
All right, maybe just ask that as a direct question then.
Okay, in the case-by-case analysis, do you intend to award avoided methane credits if you determine that biomethane would have entered the atmosphere in a business as usual scenario?
I think that perhaps calls for a bit of speculation. The way this process works is a fuel production facility applies to the department for an alternative fuel pathway. They have that application undergo third-party verification if it hasn't already done so in another state. And then that entire application package comes to the department for our review. And we will determine on a case-by-case basis, really looking at the facility, at the information the facility has presented to us, whether or not that type of crediting would be the correct assumptions for that facility. I think there are, to Ms. Gerson's point, I think that there likely are cases where assuming, or not really assuming, where there would be appropriate evidence that in the absence of the production of the fuel for the CTFP, methane would have been emitted into the atmosphere from the facility.
Okay, thank you. I would like to help identify the criteria that you intend to apply to identify those situations. So, for instance, would a facility that has been capturing biomethane in with equipment that was installed in 2017 be eligible for avoided methane crediting?
Objection, Madam Hearing Officer. The details of the question continue to ask for speculation.
Yeah, Dr. Rasso, I really don't want you to speculate. If you can answer without speculating, that's great. Otherwise, just say so.
I don't think I can answer the question without speculating.
Right?
Okay, so just to be super clear, you have not determined if there are any criteria regarding the age of the or installation date of methane capture equipment.
Objection. The question mischaracterizes the evidence in an intimidating manner. Mischaracterizes the testimony in an intimidating manner.
Oh, sorry. If you would just ask it as a straightforward question. Have you decided the criteria?
Okay. So have you established any criteria for how recently methane capture equipment would need to be installed in order to be eligible for avoided methane crediting?
The department have thought about this issue, but we have not come to any final determinations.
Okay. Would your application specific process examine whether methane capture at a particular facility would be economic without the Clean Transportation Fuel Program, taking into account other revenue sources for biomethane?
I, again, don't think we have come to any final conclusions on that.
Okay. Would the case-by-case analysis account for whether the facility purposefully increased the amount of methane it created by housing more animals?
Objection, Madam Hearing Officer. The witnesses testified to the fact that the department has not come to any policy conclusions on the manner in which it would do this. And so if Dr. Rasso can answer, but this line of questioning is continuing to require her to give the same response.
No, all right. Well, offer the same response then, if that is the response, Dr. Esso.
I don't know that we've come to any firm conclusions on that. I will say I don't believe that that is considered by other states.
Would the case-by-case analysis account for whether facilities in cold climates purposefully increased methane production by warming the manure?
I don't feel qualified to answer that question.
Would the case-by-case analysis account for whether the facility installed the methane capture equipment under a term of a legal settlement?
Objection, Madam Hearing Officer. We've established that this line of questioning is not helpful. The answers are the same.
All right. Ms. Gerson, you have approximately 4 minutes left in your questioning.
Okay.
So please prioritize.
Dr. Rasto, can you think of any circumstances under which under which pathways they're eligible for avoided methane credits in other jurisdictions would not be treated as carbon negative in the New Mexico program?
I think that would have to be evaluated on a case-by-case basis. We intend to evaluate them separately from their evaluations in other states.
And can you confirm that the only type of methane that would be eligible for avoided methane crediting would be methane from livestock manure?
I cannot confirm that because I think that avoided emissions crediting is widely available for alternative fuel pathway applications and will be evaluated on a case-by-case basis independent of the type of methane or the source of the methane.
And have you estimated how many credits parties could potentially generate through avoided methane crediting?
I think that would be better directed to other witnesses.
Okay. Can you confirm that under your proposal, parties could apply for avoided methane crediting? If
Ms.
so,
Gerson, please start your question again. The court reporter couldn't hear it.
I'm sorry. Can you confirm that parties would be able to apply for avoided methane crediting both when they use biomethane as a fuel in CNG vehicles and also when they use methane for process energy?
The department's proposed rule do allow the use of other fuel pathways as inputs for fuel pathway applications. So, yes.
So just to be really concrete, that means that there could be a negative carbon intensity value for the methane that refineries burn to produce the heat that they need to make gas, diesel, jet fuel, and biofuels, right?
Section 201, one second. As I testified to under cross-examination yesterday, Section 201A1 requires that fuels, including clear gasoline or the fossil gasoline blend stock of a blended gasoline transportation fuel, clear diesel or the fossil diesel blend stock of a blended diesel fuel, fossil fuel natural gas, and fossil LPG must be reported using the lookup table values in the rule. So they would be precluded from that type of alternative fuel pathway application.
I see. So the process energy opportunity, that's only really relevant to refineries that produce renewable biofuels.
It would be open to fuels that are allowed to apply for alternative fuel pathway applications under the rule.
Okay.
Ms. Gerson, your time for questioning Dr. Rasso is completed.
Okay. Thank you. Thank you, Madam Hearing Officer, and to all of the panel members.
Thank you very much. I'm glad you were able to remedy your sound. Shall we take a 15-minute break before we go to the next of the questioners? All right. Come back at 10:37, please. We're back after a short break. Let me go to the next set of questioners for the department panel. Is Mr. Lobdell or Ms. Rayno with us? You would be next for Food and Water Watch. No. They're up there?
That's RNG.
Sorry?
No, I don't see them, but I see RNG.
Okay. All right. Then we go to Mr. Sarayas. Yes?
Thank you, Madam Hearing Officer.
Go ahead.
Good morning, Madam Hearing Officer, Chair, members of the board. I'd like to thank everyone for being here and also thank you.
Mr. Sarayas, you're going to have to really speak up.
I understand. Okay. How's this sound?
Better.
Great. Well, good morning, everyone. And especially thank you to the panelists for their participation in this proceeding. My questions.
Wait, hold on. I'm sorry. It's really project.
Understood. Well, I'd like to thank everyone for being here. My questions are focused on clarifying the scientific and statutory basis for avoided methane crediting, as well as how NMED has structured the program in line with HB 41. I'd like to start with Ms. Borchert.
Good morning.
Good morning, Ms. Borchert. I have a few questions about New Mexico's greenhouse gas emissions profile and the legislative framework that guided NMED in this rule. Does methane from organic waste sources and manure management constitute a significant share of New Mexico's greenhouse gas emissions?
Could you repeat that? You're a little quiet, and so I couldn't hear all of the parts of the greenhouse gas emissions you were asking about.
Understood. Give me one moment. Let me try to just increase the feedback on my end, or the input rather.
Also, it might help if you have a headset, I've been told.
Understood. How does this sound?
That's better.
Great. For my first question, Ms. Borchert, does methane from organic waste sources and manure management constitute a significant share of New Mexico's greenhouse gas emissions?
Could you define significant?
Significant would be a plurality or anything close to a plurality.
So more than 2?
Sure.
Yes.
Would you agree that under direction from HB 41, technology neutral means evaluating every fuel pathway based on its life cycle carbon intensity rather than excluding an entire category in advance?
Yes.
And would ignoring greenhouse gas benefits from any fuel pathway, including avoided methane, run counter to...
Hold on, Mr. Sorayas. We're providing the court interpreter with a set of with a headset. Just
Understood.
1 moment.
And I might need one too. I am having trouble hearing.
Is it possible to turn up your volume anymore, Mr. Sorayas?
Let me try 1 moment. How's this?
That's better. Just keep it at that volume would be great.
Excellent.
The interpreter is asking if anyone else would like a headset. And one more request, Mr. Sorayas, is if you would please slow down your question so that the court reporter and the interpreters can catch it, especially when you are reading.
Certainly.
All right, please go ahead.
Ms. Borchert, would ignoring greenhouse gas benefits from any fuel pathway, including avoided methane, run counter to HB 41's direction to establish the program in a technology neutral way?
I'm just curious.
Objection,
Oh,
Madam Hearing Officer. Framing of the question calls for a legal conclusion.
All right, just caution Ms. Borchert as I have before. Ms. Borchert, please don't offer legal conclusions. If you have an answer, though, in your role as the chief of the Regulatory Bureau, please go ahead.
Wow. So I'm getting feedback. All right, I'll try to work through it. Oh. Okay, let's see if I can figure this out. And can everyone else hear the question, or should I embed the question in my answer? Or maybe I'll just make a statement that, because I can't tell what other people can hear.
So just focus on what you can hear. The rest of us are hearing through the system.
Okay. The department's approach to life cycle analyses is to be true to the science associated with the determination of a carbon intensity value. To the carbon intensity associated with each fuel.
Thank you, Ms. Borchert. I have no more further questions. My next questions are for Dr. Rosso.
Good morning. We're going to try this without me wearing the headset, and I'll let you know if you need to repeat the question with me wearing the headset.
Okay, excellent. Thank you very much. And good morning. I'd like to ask you a couple questions about the lifecycle modeling and crediting mechanics NMED used in developing the draft rule. Can the creation of renewable natural gas from manure management or organic waste diversion generate negative carbon intensity scores in the Argonne National Lab R&D GREET model because they capture waste methane and turn it into a fuel?
I'm sorry, that question was a little too complex for me to break down and answer. Perhaps you could phrase it as multiple questions. I'm sorry, I wasn't quite following you.
Certainly. Can the creation of renewable natural gas from organic waste diversion and manure management, does it generate a negative carbon intensity under the GREET model?
I think the details of how avoided emissions are actually accounted for within the GREET model might be best for another witness. I a little bit. I'll leave it there.
Okay, understood. And which witness is it on the panel? Are they on the panel?
The GREET modeling that was done for the rule was conducted by Eastern Research Group on behalf of the department. So that would be Mr. Kopal.
Okay, thank you. Another question then. How does NMED's approach to avoided methane crediting in temporary pathway scoring compare to approaches taken in other states' clean fuel programs?
As I covered in both my testimony and my oral summary, we have taken a different approach in the temporary fuel pathways than other states. We have elected to have 2 temporary fuel pathways associated with animal waste biomethane, one of which does not include avoided emissions in a counterfactual or business as usual scenario, which is not present in other states. Our other temporary fuel pathway does include avoided emissions, but we have accounted for them differently. I believe in other states, the temporary fuel pathways were calculated in a ground up manner based on the manure waste handling practices in those states. We've elected to instead look at the amount of greenhouse gases from manure waste management in the US EPA National Greenhouse Gas Inventory, and starting at that place, credit the avoided emissions possible for animal or collection of biomethane from that waste.
Thank you. And so you'd say, just to clarify, this is a more conservative approach than other states have taken.
It results in less negative carbon intensities than other states have in their temporary fuel pathways. Yes.
And what is the scientific rationale for NMED taking this approach?
These types of pathways have existed for a very long time in California, who's been running this program for 15 years. And the conditions on what should be considered avoided or what has happened since 2009 have changed.
And Dr. Rosso, I'd just like to connect that back to the statutory language in HB 41 and consistency with other jurisdictions. Within HB 41, it directs NMED to consider similar programs in other jurisdictions, correct?
Yes, that reads, it's in the statute to consider similar programs in other jurisdictions Allow for coordination with other jurisdictions to promote regional reductions or removal of greenhouse gas emissions, and allow market participants to generate credits under any overlapping current and future federal transportation fuel regulations.
Thank you. If New Mexico were to create a dramatically different approach to avoided methane crediting, would that skew incentives for where projects are built or across clean fuel states?
I'm sorry, could you repeat that question?
If New Mexico were to create a dramatically different approach to avoided methane crediting, would that skew incentives for where projects would be built across clean fuel states?
I think that's a quite complicated question given the intersection, as became apparent under the previous questioning, between book and claim crediting and avoided emissions crediting. So I'm not sure I could draw that conclusion or not draw that conclusion.
All right, thank you. I have no more further questions. Thank you, Dr. Rosso. My next line of questioning would be for Dr. Murphy.
Good morning.
Good morning, Dr. Murphy. I'd like to ask you about the scientific underpinnings of methane's impact and how other state programs have treated avoided methane crediting. In your expert opinion, do life cycle models like the GREET model provide a sound and widely used framework for evaluating all fuels on a consistent basis, including RNG and biofuels?
Yes, I wouldn't say any model is perfect, but GREET is absolutely widely used in the space, has an extensive track record of peer-reviewed publications behind it, and is generally sound.
And does 1 ton of methane have a greater near-term impact on climate warming than 1 ton of carbon dioxide?
Yes.
Other state programs use farm-specific historical baselines to assess avoided methane emissions, correct?
That's definitely the case in California. I believe it's also the case in the other states, but I'd have to go back and refresh my memory on their methodology to be certain.
And, as is the case in California, wouldn't that mean that there's no incentive for a farm without liquid manure management to switch to liquid handling because they would receive no avoided methane credit?
I don't think it's fair to say they would receive no avoided methane credit. If you're comparing against the previous approach at a farm level, you look at how much emissions were there in the previous baseline and then compare it to the emissions afterwards, after the project has been developed. As Dr. Rosso mentioned, the specific emissions and baselines and counterfactuals have to be assessed on a case-by-case basis. Generally speaking, dry manure management operations have less fugitive emissions, certainly not zero, but less than wet. But yeah, I don't think you can make the absolute point, but I do think there would be we would typically expect in most cases a smaller incentive.
A smaller incentive for farms that are using dry manure management.
Yeah, the avoided methane credit, all else being equal, in general, we would expect the avoided methane credit they'd get would be smaller than one whose previous approach was a liquid management.
And Dr. Murphy, in your expert opinion, has California's low carbon fuel standard driven significant methane reduction and clean fuel production at California dairy farms?
It has. On the methane reduction side, it's the only policy California has adopted in order to, certainly the most significant by far, to address this issue. It doesn't mean it's the only possible way to do it, but this is the approach California has taken, and yes, it has driven methane reductions.
Thank you, Dr. Murphy, and thank you to all the members of the panel. Madam Hearing Officer, I yield my time.
Thank you very much, Mr. Sorayas. Mr. Nasco has already asked his questions. Is Mr. Duff with us? Is Mr. Jed Smith with us? See, I saw Ms. Veracruz earlier. Do you have questions of the department panel? Ms. Veracruz said she does not. Next, we go to Mr. Noyce.
Graham Noyes, appearing on behalf of the SAF producer group, including GEVO, NXT, and World Energy. And I'd like to start here with Dr. Rasso. I'd like to revisit the discussion of the book and claim system. And my first question to Dr. Rasso is, in terms of designing the regulatory language for the program, was it the intent and your intent in particular to design regulations that were sufficient in themselves to answer all questions and instruct participants with how to comply with the regulations?
As I believe we've spoken to yesterday, we do intend to issue additional guidance document to clarify participation in the rules.
And regarding those guidance documents specific to the area of book and claim, what kinds of subject areas would you anticipate that those guidance documents would pertain to?
As I spoke to yesterday, I have a list of, I think I said 50. I would have to visit the exact number of my list, but of 50 areas of guidance, standard operating procedures, and templates that we need to prepare. With book and claim, the one that rises to mind right now would probably be the list of, let me get the language correct from the rule here. The list of tracking programs recognized by the department for the retirement of environmental attribute certificates.
Thank you. And referring to the proposed section 201C5, this is the book and claim provision that was discussed during a recent cross-examination. And that is for gaseous or liquid fuel, and requires in part that the fuel reporting entity must retire environmental attributes in a tracking program recognized by NMED on a quarterly basis. Is that an accurate summary, would you say?
I think so, yes.
And regarding the prior cross-examination, reference was made to California Guidance Document 1905. That is the reporting and record keeping for natural gas and book and claim accounting for biomethane as revised May 2024. Dr. Rasso, have you had any experience or opportunity to review that document?
I have not reviewed that document.
All right. Given the recent cross-examination, I'd like to make some specific references to that, because that was discussed at some length and served as the basis for hypotheticals. And this is beginning on page 4, and I'm just pulling the key points and skipping lots of material here, and we'll move through it quickly, but not too quickly. And so it begins by stating, requirements for using book and claim accounting for biomethane include the entity claiming the environmental attributes must demonstrate the exclusive right to claim environmental attributes associated with the sale or use of the biogas or biomethane. Second, the pathway applicant and fuel reporting entity must be able to link the environmental attributes of biomethane with corresponding quantities of natural gas withdrawn for transportation use in California. Number 3, The quantity of environmental attributes claimed under the LCFS may not be used or claimed in any other program or jurisdiction with the potential exception of the federal renewable fuel standard and California's cap and trade program. And then the guidance document goes to cite several examples of double claims that are prohibited under the LCFS regulation. Double claiming occurs if a unit of biomethane is linked with a larger quantity of natural gas withdrawn. If the same unit of biomethane is claimed in California under the LCFS and claimed as used in another state under the federal renewable fuel standard, if the same unit of biomethane may not be claimed as used as multiple CNG fueling stations in California, and the same unit of biomethane may not be claimed as feedstock for hydrogen production and claimed as dispensed as bio-CNG, regardless of whether the dispensing location is inside or outside California. Dr. Rosso, do those kinds of requirements strike you as the types of things that NMED would seek to include in its guidance documents?
Not having reviewed the document itself and just having listened to you paraphrase parts of it, I would tend to agree.
Thank you. The additional requirement here that is applicable is the use of a third-party verification. And the specific provision there is when the quantity of fuel with a CI that reflects the emissions associated with biogas or biomethane is reported in the LRT CBTS system. That's the CARB system by a fuel reporting entity. The environmental attributes are deemed retired and can no longer be sold, transferred, or claimed by any entity or for any other purpose. This requirement may be clearly demonstrated when the fuel reporting entity is the final owner of the attributes. In addition, the pathway holder and the fuel reporting entity must submit the attestation to CARB as set forth in a specified section, as well as obtain and keep environmental attribute attestations from each upstream party, collectively demonstrating that the entity claiming the environmental attribute has the exclusive right to claim environmental attributes associated with the sale or use of the biogas or biomethane, and the environmental attributes have not been used or claimed in any other program or jurisdiction, with the exceptions provided in the LCFS regulation. Dr. Rosso, I understand you're hearing these pieces of the guidance document from CARB for the first time, but does this strike you as a robust system for imposing limitations on the use of environmental attributes, requiring attestations and verifications such that program integrity is maintained?
I think maybe because I lost you a little bit there, it was quite lengthy. The best thing for me to say here is that we probably will be issuing guidance documents around retirement of environmental attributes within our system, and we will likely be considering guidance that other states have issued as we consider that guidance documentation.
And also regarding...
I'm sorry, Mr. Noyes. You are reading too rapidly for the interpreters. Just slow down a little.
Thank you, Madam Officer, and I have completed my reading. So, but I will maintain, try and be diligent on that front. Now, in terms of one of the other issues that's been covered, which is the use of the environmental attributes in the Federal Renewable Fuel Standard and the Inflation Reduction Act. Dr. Rosso, are you aware that under 45Z of the Inflation Reduction Act, that crediting could be up to $1 per gallon for a fuel with a low CI score?
I'm not familiar with the particulars of the 45Z tax credit.
And are you familiar that under the Renewable Fuel Standard, there are various types of RINs, and those RINs have had fairly widely varying credit in the range of from just a penny to up to $3.50 per gallon, and that those that was the question.
I am familiar that within the Renewable Fuel Standard, there are various types of RINs that go for various prices. I cannot speak to the historical price ranges.
Understood. And from a New Mexico consumer perspective, would you see a benefit from fuels receiving all the federal incentives that might be available to reduce the net cost to consumers at the pump for any of these low carbon fuels?
I think that we considered, I'm going to be careful here because I don't want to speak to fuel prices. I'm not an economist, but I think as we were drafting the rule, we were careful to consider impacts of making sure that that fuels delivered to New Mexico for participation in this program were eligible to participate in the renewable fuel standard for a reason.
Thank you. I would like, with that actually, I would like to request that CARB LCFS document 1905 be entered into the record, and I'll do a written filing on that, and would use that to support a motion to strike the Ms. Gerson's cross-examination based on the divergences in her hypotheticals from what is contained in California guidance document.
All right, I'll look for the motion. Right now, though, is there any objection to that bit of guidance or rule coming into this record?
Madam Hearing Officer,
Ms. Sona?
No objection to the portions of the document that Mr. Noyes read. Having not seen the entire document in the pre-disclosures with the NOIs, I would be concerned about agreeing to the entirety of that coming in. But for the purposes of maintaining clarity that he read into the record, that seems reasonable.
All right. Mr. Noyes, I'm sorry, did someone else speak?
Madam Hearing Officer, this is Sarah Gerson for CCE. May I have a word?
Yes.
It seems appropriate that the document that Mr. Noyes is referring to might be part of the administrative record, but not the evidentiary record for this case because no foundation has been laid for it.
Okay. So I think, though, that we can take administrative notice of it for purposes of the evidentiary record, and we're not really keeping a separate administrative record at this point. The evidentiary record becomes part of the administrative record upon which the board bases its deliberations, or vice versa. So, are there other comments on, again, just the submission of the portions that he read for purposes of cross-examination of the department panel? No? All right. If you would then please, Mr. Noyes, pursuant to Ms. Sona's objection, just submit the portions that you read. They'll become part of the what's effectively a cross-examination exhibit.
Thank you, Madam Hearing Officer. Dr. Russo, turning to another issue here, in your direct testimony, you stated that as a principle, NMED's goal was to maintain consistency with other programs wherever possible. Is that an accurate summation?
Yes.
And what are the reasons supporting this principle?
Well, there's several reasons supporting this principle. The first of which is the statute, the underlying statutes. One of the 10 items listed in Part C of that statute was to consider similar programs in other jurisdictions. The secondary reason for this, as I mentioned in my oral summary, is that remaining consistent with other programs eases the administration of this program, since we have many of the same regulated parties. When our rules can be consistent with other states, it helps the regulated parties with participating in our program.
And Dr. Russell, would you say that other states also generally follow this principle?
I'm not sure I can speak to all other states on that matter.
Understood. And regarding specifically the issue of alternative jet fuel crediting, alternative jet fuel is available for crediting on an opt-in basis. Is that correct?
It is listed as an opt-in fuel.
And its crediting structure is based on the difference between the carbon intensity of the alternative jet fuel and the carbon intensity benchmark contained in Table 3. Is that correct?
Table 3 is the carbon intensity standards for alternative jet fuel, yes.
And when one compares the carbon intensity standards in Table 3 with those of Tables 2 or Table 1, Table 2 being diesel and Table 1 being gasoline, is it accurate to say that there's, because that Table 3 has a much lower set of CI benchmark scores, that alternative jet fuel crediting is discounted on a per gallon basis for the same CI score as compared to either gasoline or diesel fuel?
I'm sorry, I'm not entirely sure I followed. Could you please repeat the question?
Certainly. To back up some, when one is calculating crediting for a particular type of fuel, is it the case that the standard that's established in the table minus the carbon intensity of the low carbon fuel forms the basis for the credit calculation?
Yes, that is part of the credit calculation.
And just referring specifically to Table 2 on diesel fuel, the Table 2 diesel fuel values are approximately 10% higher than the alternative jet fuel table. Is that correct?
They're higher. I haven't done the math on the percentage.
And as a result of that, those on a per gallon basis, that would be discounted crediting if the same gallon of fuel were used and sold into the diesel market as opposed to the jet fuel market. Is that correct?
Assuming that they have the same energy density and the same EER, yes.
Point well taken. Thank you. And are you aware that in the California and Oregon program, there were measures taken in the program design to levelize the crediting between diesel fuel and jet fuel?
I believe our curve for alternative jet fuel does look different than that in those programs. The reasoning for that is that to maintain technology neutrality, alternative fuels are compared to the conventional fuel in our program. And in the case of alternative jet fuel, the correct conventional fuel is fossil jet fuel.
Isn't it the case, Dr. Rasso, that jet fuel is not an obligated fuel?
That's correct.
And so in that respect, isn't the program treating jet fuel differently than gasoline and diesel fuel?
Sorry, I've lost track of the button on my microphone. Jet fuel is not regulated. Fossil jet fuel is not regulated under this program because of my understanding. I should specify that I am not a lawyer as I give this answer. My understanding of why we don't and other programs don't regulate fossil jet fuel is because it brings in interstate commerce clause issues to these programs. Alternative jet fuel being an opt-in fuel does not engage those same types of issues because, because it is an opt-in fuel.
And are you aware also that Washington State bases its alternative jet fuel crediting on the diesel standard in the program?
I don't think I can speak to the specifics of how Washington has set their curves.
And returning to the principle of program consistency with the other programs, is it fair to say that this different treatment of alternative jet fuel in the New Mexico program does not conform with that principle of consistency?
Objection, Madam Hearing Officer. The foundation for the question's lacking because the witness already stated she couldn't speak to what Washington does, and the question presupposes that she stated she did know.
If you can lay a foundation, Mr. Noyes, go ahead.
Well, perhaps I'll just pose it this way. Assuming that all the programs in California, Oregon, and Washington all have aligned crediting for alternative jet fuel with renewable diesel in particular, to the extent that New Mexico takes another approach, that would be a divergence from the general principle of program consistency. Is that correct?
I think you're correct that it diverges from program consistency with other states. I would also say that we here have an issue where we are dealing with two apparently conflicting directives from the legislature. We have one directive to maintain technology neutrality and one directive to remain consistent with other states. And in this instance, the department has decided to follow the directive to maintain technology neutrality.
Thank you, Dr. Rasso. I'd like to question Dr. Murphy.
Right.
Good morning, Dr. Murphy.
Good morning.
Nice to see you here in New Mexico.
Yeah,
We've seen each other in some other venues out there.
a lot of hearings and workshops like this.
Dr. Murphy, are there mechanisms in low carbon fuel programs that can help to mitigate or alleviate the effects of pass-through costs to customers that purchase fuel at the pump that would result in downward price pressure?
Yes. So first I would say, as I mentioned in my testimony, the use of a market-based mechanism to allow regulated parties to find the lowest cost option is basically the gold standard in environmental policy for minimizing costs. And the evidence we've seen in other states so far indicates that it's serving that function. In specifics particularly as you get deeper in the program over the long run, as you introduce other fuels into the transportation fuel market, you bring competitive pressures that don't exist in a world where petroleum is the only option. The basic laws of economics say when there's only one product, then the sellers of that product don't have as much sort of pressure to price compete against each other. So the existence of alternatives to petroleum for transportation fuel would be expected to put downward pressure on prices, and also as the transition to cleaner transportation moves forward, fewer and fewer people would be subject to any gas price increases that would result. That is, as the target goes up, it reflects a transportation market that is evolving and moving further away from high carbon fuels. The way you reach those targets is you have more biofuels, more electricity, more other things. And if somebody's using these lower carbon alternatives, they're not paying the gas price impact. So that also, again, sort of plays into these competitive dynamics where the less you demand of something, typically the price tends to go down.
And Dr. Murphy, have we seen fuel diversification occur in the other states with clean fuel programs?
Absolutely. Prior to the existence of clean transportation fuel programs, along with other programs to support sustainable transportation, basically everybody in the U.S. drove on gasoline, often blended with ethanol or another oxygenate, but predominantly gasoline. Now, we have seen in California a significant increase in the amount of electricity. We've seen over 80% of the liquid diesel in California has switched to a biomass-based diesel substitute. So there is a diversity of fuels, and these trends we're also seeing them in every other jurisdiction that has adopted policies like this. Many of them are several years behind. They're not sort of as far advanced because they adopted their policies later. But in every case, we are seeing a diversification of the fuel pool.
And in a specific situation of high blend ethanol, E85, 85% ethanol, or up to 85% ethanol and 15% gasoline in the California market, are you aware that the combination of the California's Clean Fuel Program and the federal incentives has led to ethanol, typically E85 ethanol, typically being priced at $1.50 to $2 per gallon less at the pump than conventional gasoline?
I've certainly seen examples of that. I have not done a systematic study of the relative price, or I've seen them, but not recently enough to remember them. But certainly I've seen examples, and that sounds quite reasonable.
And Dr. Murphy, you stated in your testimony that technology neutrality is a common theme in clean fuel programs. Is that accurate?
Yes, technology neutrality does mean different things to different people. There isn't sort of one absolute perfect objective definition of what technology neutrality means. And I will say, in my experience, it's often leveraged to mean what the particular speaker at the moment wants it to mean, and to benefit their particular interests. But the basic idea of letting a fuel get incentives proportional to the greenhouse gas reductions that it provides, that is common to all the clean fuel programs we've seen deployed so far. And I think in a lot of ways, that's sort of the essence of technology neutrality.
Thank you, Dr. Murphy. I'd like to pose some questions to Ms. Boucher. Ms. Boucher, continuing on the issue of technology neutrality, and this is going back to some of the comments of both Dr. Rosso and Dr. Murphy. Is it accurate to say there was some tension in interpreting the statutory language between the references to technology neutrality and the reference in the statute and the references in the Clean Fuel Program statute to consistency with other programs specific to the issue of the appropriate level of crediting for alternative jet fuel?
Yes, and just my last name rhymes with orchard, so it's Borchard. But yes, I agree with what Dr. Rosso said, that these directives in C sometimes are required us to make some interpretations about which ones to apply.
Thank you, and the rhyming is very helpful for me. And is it accurate to say there's no definition of technology neutrality either in the statute or in the regulation as proposed?
Objection, asked and answered by different counsel.
Yes.
I'll withdraw the question. Ms. Borchard, is it accurate to characterize the central aspect of the program as the reduction of the carbon intensity of gasoline and diesel fuel?
Could you repeat the question while I also look at the statute?
Certainly. Is it accurate to characterize the central aspect of the clean transportation fuel emphasizing standard being the reduction of the carbon intensity of gasoline and diesel fuel?
Well, C1 says establish a statewide technology neutral clean transportation fuel standard based on a schedule for annually decreasing the carbon intensity of transportation fuels used in the state. So I think that your question was narrowly focused on gasoline and diesel, and the statute uses the word transportation fuels more generically.
And regarding the distinction you've made there, the two tables that establish standards are for gasoline substitutes and diesel substitutes. Is that accurate?
Yes, and the reason for that is because we assign Table 1 gasoline and gasoline substitutes for light duty vehicles, and then we assign Table 2 to the use of transportation fuels in medium and heavy duty vehicles.
And so based on that, producers and importers of those types of fuels are obligated to meet those standards annually and to offset their deficits with sufficient credits. Is that correct?
Yes, that's correct.
And I think, as you referenced, those obligations are established under 74-1-18C1.
Correct.
Is it also accurate to summarize that a secondary method of credit generation are additional credits that provide carbon reduction and removal under C3 of that same section?
Yes, that's correct. That's my understanding. I don't want to, cross over into the interpreting of the law as an attorney, but that's how we've applied it when we created these rules.
Right, and consistent with this overall structure, in your presentation that accompanied your testimony, you showed the Table 1 standards for gasoline and gasoline substitutes, and the Table 2 diesel and diesel substitutes, but not Table 3 pertaining to the crediting for alternative jet fuel. Is that correct?
The graph I presented in the first figure of my presentation did not include the conventional jet fuel standard. Right, that's represented by Table 3.
And is the reason for that Table 3 is not actually part of the clean fuel standard that mandates these carbon intensity reductions, but instead is the basis for crediting on an opt-in basis?
Yes, that's correct.
So would it be accurate to characterize those Table 3 CI scores as the crediting benchmarks for alternative jet fuel rather than standards for jet fuel, given that conventional jet fuel does not have a standard under the program?
I think that I would generally agree with that.
And so would you agree in that respect that Table 3 is fundamentally different than the Table 1 and 2, which set the annual standards?
I also agree with that.
Regarding the level of jet fuel crediting, are you aware that the benchmarks for that are significantly lower than the CI standard for gasoline and diesel fuel contained in Tables 1 and 2?
I feel like that's repetitive from what you asked Dr. Russo, but I can do the math as well as she can.
And the reason for that lower carbon intensity is because the baseline score for jet fuel, for conventional jet fuel, is lower than that for gasoline and diesel based on the life cycle analysis, correct?
Correct.
And are you aware that the primary reason for that lower CI score is the fact that jet fuel is less processed than diesel fuel because it's not subject to the desulfurization process?
I certainly cannot speak to that. That seems like a question for our experts from Eastern Research Group.
Very well, I'll hold that question. Do you agree that the on-road fuel standard for diesel fuel in New Mexico is less than 15 parts per million?
I'm sorry, could you repeat that question?
Yes. Are you aware that the on-road fuel standard for diesel fuel is less than 15 parts per million of sulfur?
That's also out of my expertise.
And so you're probably not aware that jet fuel is typically in the 800 to 1,000 part per million level of sulfur.
Yes, I am. That's outside of my area expertise.
Madam Hearing Officer,
Ms. Sona.
the witness has established she doesn't have knowledge to answer these, and so to the extent they're being included in the record to set effect, I would just ask Mr. Noyes to strike those answers and then reserve those questions for the correct witness.
All right, Mr.
I
Noyes.
have no objection to that.
All right, thank you.
Turning to the issue of air quality, Ms. Borchardt, can you speak to the benefits of ultra-low sulfur diesel fuel is it within your area of expertise?
It is not.
Moving on, is NMED supportive of attracting alternative jet fuel to New Mexico to gain the air quality benefits and greenhouse gas reduction benefits of that fuel?
NMED is supporting of the opportunity for all fuels that are credit generating and that reduce the transportation fuel and improve air quality to come to New Mexico. Projects and fuel.
Is there an interest in trying to establish New Mexico airports as SAF hubs that have SAF availability? So, and SAF, I don't believe has been referenced before, referring to sustainable aviation fuel, which is within the scope of alternative jet fuel.
Could you repeat the question, please?
Certainly. Is there an interest in having availability of SAF at both private and public airports in New Mexico?
Objection, Madam Hearing Officer. I believe this is outside the scope of Ms. Borchardt's testimony,
All right.
but would defer to her.
Yes, please say so, Ms. Borchardt, if that's true.
I can generally say that when we at the Environment Department, as Director Miano testified, are encouraged to consider all the different ways in which we can hit the trifecta between providing economic opportunity, improving health outcomes, and also reducing greenhouse gas emissions in the state. So to the extent, without having details, that increasing SAF use in New Mexico hits all those three targets, then in general terms, in terms of what we try to do, I can say that the state in general supports those kinds of opportunities, economic opportunities.
Thank you. Outside of the issue of technology neutrality, which we've spoken to already, was there any other policy reason or other reason that NMED established a lesser level of crediting for jet fuel or alternative jet fuel as compared to diesel and gasoline?
Could you restate the first part of your question or the whole thing?
Certainly. We've previously discussed that the principle of technology neutrality was in the statute and was a reason to essentially set the benchmark and the curve for jet fuel crediting to be parallel with the curves for gasoline and diesel crediting. And as a result, we have about a 10% discount compared to diesel fuel. Was there any policy reason for doing that other than wanting to be technology neutral regarding the methodology there?
I believe this was asked and answered. If this is different, if counsel could clarify.
Yeah, I don't remember that this particular question was asked and answered. Ms. Borchardt?
Well, it's I'm a little I'm trying to make sure I don't bite into all the assumptions of that question. So I'm going to just rephrase the answer as we base it seems appropriate when we apply science and life cycle assessment in particular to science of life cycle assessments to our rules, that the baseline against which SAF and other alternative jet fuels are measured is the use of these fuels in New Mexico. Thus, the curve on table 3, which is the baseline for what was the carbon intensity of conventional jet fuel in 2018 in New Mexico.
And given the fact that under the statute, the jet fuel crediting is based on essentially opt-in crediting as an additional mechanism, and the other fuels are based on standards, did you, as lead of the rulemaking team, not think that NMED had discretion to follow the other program structures out there that had more comparable crediting?
I don't think it's a question of discretion. We applied our understanding of what the science required in this case to develop Table 3.
And Ms. Borchardt, are you aware that the processes for producing alternative jet fuel, which in the U.S. is all at this point commercially produced through the HEFA process, or the vast majority is also the same process for producing renewable diesel? Are you aware of that technology alignment?
Yes, thanks to many conversations we had with you, I am aware of that.
And are you also aware that the producers make the decision whether to choose to produce alternative jet fuel or renewable diesel based on which fuel is more profitable to produce?
Again, I can refer to conversations we had with you and also I can understand the delta between the standard and the amount of credits that basically somebody would get as perhaps driving decisions that a company makes on the choice to produce renewable diesel versus SAF.
And so you understand that the result of the discounted crediting is likely to be lesser and potentially non-availability of alternative jet fuel in New Mexico under the program structure?
I can't say that because I feel like it's one of the many factors that could determine whether that's true or not. Right? There's a lot of other economic factors that could determine whether any producer decides to bring fuel to New Mexico that could be well outside of just this delta.
Thank you, Ms. Borchardt. That concludes my cross-examination on behalf of the SAF producers, Madam Hearing Officer.
Do you have questions on behalf of Infinium or Verde Clean Fuels?
I do. I'd like to move on to Verde, if I may.
Go ahead.
Thank you. Ms. Borchardt, I'd like to stay with you as we move to Verde Clean Fuels. Through your work at NMED, is it accurate to say that the control and beneficial use of methane is a priority in New Mexico?
Yes, in particular, the executive order from our governor in 2019 that sets greenhouse gas emission targets for 2030 and subsequent policy of hers by 2050 specified a number of directions that our governor was seeking for us to reach those targets, and one of them was the reduction of methane in our state from the oil and gas industry.
And additionally, are you aware that within the Permian Basin and in other parts of the state, there is substantial methane produced as a co-product of oil production?
Yes, I am aware.
And have you become aware through this rulemaking process of Verde Clean Fuels methane to gasoline technology?
Yes, I have.
And from a Climate Change Bureau perspective, is it correct to say that the program structure that we're speaking about today helps to it helps to enable the development of clean fuels like Verde's facilities, and the conversion of methane to gasoline would be a positive environmental outcome for New Mexico?
I would need to really see what they propose, or actually, which my colleague Dr. Rosso would need to see those, because what I am not quite clear on about Verde's processes is to what extent they are additional beyond the ozone precursor rules and the methane waste rules that exist in the state.
Right, and to your point there, Ms. Burchard, in order to participate in the program, Verde or any other clean fuels would have to undergo a life cycle analysis to answer the questions that you've just raised.
Not only a life cycle analysis, but also an application for an alternative fuel pathway if they want to deliver the gasoline through their processes to the state and for consumption in the state.
Understood. In developing the program structure, do want to express great appreciation for the work that was done, and one of the components of that was developing a definition for synthetic fuel. Is that correct?
Yes.
And again, from your presentation yesterday, synthetic fuel was referenced as sort of one of the categories where there's eligibility for to be a credit generating fuel.
Oh gosh, I'm sorry. I feel like now I'm already forgetting whether synthetic fuel is listed as an opt-in fuel. If that's your question, synthetic fuel. That's not your question.
That's not my question.
Okay.
No, that was general. That you thought it appropriate to include synthetic fuel as a definition that was included within the regulatory structure.
Absolutely. And I just also want to add to that, synthetic fuel for us is considered the catch-all phrase for the future, which is Dr. Ross called it future proofing, right? Through talking to companies like Verde and others, we understand that there are many, many DME, as Dr. Murphy mentioned earlier, many kinds of fuels that chemists, smart chemists, and innovative chemists are considering to bring to the transportation fuel world. And the definition of synthetic fuel under S5 of, just for the board's edification, of our definition section, which I think is 7, is meant to be the catch-all definition under which this world that is unfolding before our eyes and is vast and innovative can find themselves in our program.
Very good. And so from that description, Ms. Borchardt, that suggests that you intended to create that as an expansive definition that would capture fuels perhaps that have not even yet been developed. Is that accurate?
That is accurate.
And that definition was intended to include fuels like Verdes, which are typically referred to in the industry as gas to liquids fuels or methane to gasoline fuels.
The definition, synthetic fuel, is meant to capture fuels like that. Yes.
Thank you, Ms. Borchardt. That concludes the cross-examination on behalf of Verde Clean Fuels.
All right. Do you have any cross-examination on behalf of Infinium?
I do.
Go ahead.
Thank you.
Ms. Boucher, I'm afraid you continue to be
All right, I'm
the
ready.
primary person to speak to on these issues. This is a revisiting from a completely different angle on the issue of book and claim, specifically book and claim for carbon intensity, for essentially sourcing carbon intensity from offsite sources. And the reference in the regulation is 20.2.92.206. Carbon intensities for electricity. And these questions are regarding Infinium, which is an e-fuel company. And as the name suggests, e-fuels are made out of electricity. And so the carbon intensity of electricity that goes into e-fuels is a controlling factor in what their life cycle analysis will look like.
Can you, first of all, I'm
Sure.
sorry to interrupt you. If I didn't, you said 92 and then I kind of lost track on which
So
hundreds you're talking about?
Yeah, so this is 206 and specifically 206E is the portion that I'd like to speak to you about.
And I would like to have you address Dr. Rosso since the 200s are really.
Oh, that's right. I'm in Dr. Rosso country.
Yes, you are.
I stand corrected.
All right, we were on 206E.
Subsection E, yes. And E, subsection 1, actually, there, pertaining to offsite sourcing of renewable energy via environmental attributes. And that was originally defined in the what I call the petition draft as this is there's a string of requirements, and then subsection subsection F, as in Frank, previously stated RECs may not be utilized for any other programs. And Dr. Rosso, are you aware that I think several members of industry raised concerns? RECs, first of all, to back up, RECs refer to renewable energy certificates, which traditionally have been used in renewable portfolio standards to show utility compliance with having sufficient renewable energy. And so, Dr. Rosso, are you aware that there was industry concern around the very broad statement in 1F there that RECs may not be utilized for any other programs?
Yes, I believe we had heard from you on behalf of your clients on that issue.
Do you recall the nature of that concern in terms of other program opportunities?
I probably cannot encapsulate the entire concern without referencing.
To refresh your memory, do you recall references to the opportunity to potentially generate RINs under the federal renewable fuel standard and the various types of Section 45 credits, in particular under the Inflation Reduction Act?
Those seem familiar and similar to conversations around the similar language for book and claim for gaseous and liquid fuels that we were discussing earlier.
And in the revised petition draft, that language became somewhat more flexible in that it stated RECs shall not be claimed in the CTFP for fuel reported in any other program that would cause the environmental attribute to be claimed more than once. Were you involved in the development of that language?
Yes.
Can you explain the intent of that revision?
The intent of that revision was to allow the RECs to be claimed for participation in programs like the Renewable Fuel Standard and renewable fuel federal tax credits, while precluding them from being claimed for programs like renewable portfolio standards.
I appreciate that. And is it accurate to say that NMED's goal here is to enable the federal crediting to occur in the industry would say, in addition to state level clean fuel program crediting?
I think the way I would phrase that is that we intend incentives for production of renewable fuels to be stackable as long as stacking them would not cause double counting of emissions benefits.
Understood. And is it accurate to say that one of the positive reasons for this is it reduces costs to consumers at the pump to benefit for the same gallon of fuel to benefit from those federal credits?
I think I'm going to decline to answer questions about effects of fuel prices based on the fact that I'm not an economist or qualified.
Understood. And Dr. Rasso, is it your opinion that this revised F essentially achieves the purpose of enabling that federal crediting specifically for the RFS and Inflation Reduction Act provisions?
I think that was our intent.
Thank you, Dr. Rasso. If I may raise one question with Dr. Murphy, or maybe one or more. Dr. Murphy, regarding the stacking of credits, is it your opinion that enabling the stacking of federal credits, such as from the RFS and Inflation Reduction Act provisions, can bring down the final cost of the fuel at the pump to consumers?
Yes, in general, alternative cleaner fuels have sort of a higher fundamental cost than petroleum. They're newer, they have not spent as much time maturing, so policy incentives are needed to close that gap. If you have multiple sources of potential incentive, a federal incentive plus a state, then you have kind of more hands carrying the load, so to speak. If you eliminate that stacking, then in order to close that gap, one program would have to do all the work.
Thank you, Madam Hearing Officer. That concludes my cross-examination for all witnesses. We were going to look for a point. I want to be convenient to lay the foundation for my testimony. That could be now or at another point, but I just wanted to raise that.
Well, let's see. You will be presenting after the next department panel, right?
That's correct.
Okay.
And co-counsel is here today, and so we're available anytime today. And I would estimate that to be a 5-minute left or less exercise.
All right. Well, it is 11:54. We have 6 minutes to optimize. Mr. Noyes, do you swear or affirm to tell the truth?
I do.
Thank you. Ms. Menard? I think Ms. Sona has a microphone for you. Oh, there you go. Thank you for making this work. I know it's awkward.
Thank you, Madam Hearing Officer. My name is Anne Menard, and I am co-counsel for all three parties that Mr. Noyes just cross-examined on behalf of, which is Birdie Clean Fuels, Infinium, and the SAF group. Mr. Noyes, what is your name? What is your name?
My name is James Graham Noyes. I go by my middle name, Graham.
And where are you employed?
Noyes Law Corporation. I'm a sole practitioner with a practice that focuses on low carbon fuel programs in particular.
What other position have you occupied relating to low carbon fuel programs?
For 9 years, I was the executive director of the Low Carbon Fuels Coalition. I was a co-founder of the coalition. It is an organization that continues to represent low carbon fuel producers and developers and other companies that are interested and support clean fuel programs. It's dedicated to the support and expansion of low carbon fuels. And through that work, I've participated in all of the CARB rulemakings since 2015, as well as the legislative process and regulatory process in Oregon, Washington, and New Mexico. And I would note that Robin Veercruz is now the executive director of the Low Carbon Fuels Coalition and is also present here today.
Moving to Infinium first, is Infinium Exhibit 5 a copy of your written testimony?
It is.
Do you have any corrections you'd like to offer for that testimony?
It's not a correction, but by way of clarification, due to the timing of the submittals, all references in the testimony are to the petition draft. And so there have obviously been changes. And in this proceeding, we've often been referencing the revised petition language.
Is Infinium Exhibit 6 a copy of your CV?
It is.
Have you prepared a summary of your testimony on behalf of Infinium?
I have.
Could you please provide your summary?
I believe we'll be doing that at another time.
Okay. With regard to Verde Clean Fuels, is Verde Exhibit 5 a copy of your written testimony?
It is.
Do you have any corrections to offer for this testimony?
This also the same reference to the language changes that have occurred from the petition draft to the revised petition draft, otherwise none.
Have you prepared a summary for this testimony?
I have.
And will you be providing your summary later?
Yes.
Okay. With regard to the SAF producer group, is the SAF producer group Exhibit 3 a copy of your written testimony?
It is.
Do you have any corrections to offer for this testimony?
The same correction noted, but it was more prominent in this, in that the CI calculations for alternative jet fuel were the benchmark chart was changed. And so all of those calculations are now incorrect from a revised petition draft perspective.
Is the SAF group Exhibit 4 a copy of your CV?
It is.
And have you prepared a summary of this testimony?
Yes, I have.
And will you be providing your summary later?
Yes.
No further questions.
Would you like to offer the exhibits?
Madam Hearing. No.
No?
We'd like to reserve on that, please.
All right, that's fine. Thank you very much, Ms. Menard and Mr. Noyes. Let's take lunch and come back at 1. Is there anyone present in the room who is here to offer public comment? This is one of many opportunities to offer public comment in EIB 25-23, rulemaking on the Clean Transportation Fuel Program. Anybody in the room? No. Is there anyone on the platform here to offer public comment? There'll be another opportunity, 1 o'clock each day. You have a hand?
Okay.
Yes or no?
Yes, Teresa.
Teresa, would you unmute yourself, please? And camera, if you have it.
Can you hear me?
Yes, thank you.
Great.
Tell me your first and last name and spell them both, please.
Absolutely. It's going to take a second because they're both long, but
I'm sorry, I can't hear you. Would you speak up?
my name is Teresa Savidanes, and it's going to take me a second to spell them because they're both long. So bear with me. I can also put my name in the chat if that would be helpful. Would that work instead?
Actually, the court reporter can hear you, and I can hear you very softly. Did you spell your first and last name, please?
I'm trying to. I just said I can put it in. My name is very long. I can put it in the chat if that would be helpful. Can you hear me okay?
I don't start your time until after you've spelled your name and taken an oath.
Okay, I can spell it. Sorry, I don't. Can you hear me?
Yes.
Okay, sorry. First name is Teresa, Tereza. Last name Savidanes, Cevidanes.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Okay, I'll start your time.
Great, thank you. Could you just remind me how long I have? I'm sorry.
3 minutes.
Perfect. Thank you. Good afternoon. Apologies for any technical challenges there. My name is Teresa, and I'm testifying today on behalf of Americans for Affordable Clean Energy, or AACE, a nonprofit organization established by several of the country's leading retail fuel companies. AACE's mission is to educate policymakers and the public on how to best diversify our nation's transportation energy portfolio. AACE represents dozens of retail fuel locations in New Mexico. We're eager to work with the Environmental Improvement Board as you implement the CTP in New Mexico and for the opportunity to comment on this proposed rule. Our industry is experienced and well-versed in operating under CTP-type regulatory frameworks, including the California Low Carbon Fuel Standard and the Federal Renewable Fuel Standard. We generally support both of those programs. New Mexico should carefully implement its CTP to ensure that the primary objective is consumer adoption of low carbon fuels. This objective is best facilitated by, among other things, adopting a technology neutral program that, one, obligates fuel producers and importers rather than retailers or consumers to generate program deficits, two, avoids counterproductive opt-in schemes that incentivize certain fuels like sustainable aviation fuel over others for reasons unrelated to emissions attributes, and three, prohibits credit generation for, quote, co-processed, end quote, fuels. AACE's principal concern with New Mexico's proposed implementing regulations is that they could be construed to impose obligations on intra-state fuel distributors and retailers, a result that would increase costs without any offsetting uptick in investment for clean fuels. It would further create administrative inefficiencies and generally undermine the CTP's stated objectives. Today, no active statewide CTPs or low carbon fuel standards include fuel dispensers in the definition of a regulated party, nor, to my knowledge, does the underlying statute enacted in New Mexico. The Environmental Improvement Board should modify the definition of regulated party to align with other states and best support the success of the CTP. Sound CTPs function effectively only when compliance obligations are assigned solely to producers and importers of petroleum fuels. These are the entities that control the inputs and environmental characteristics of the fuels that are sold in New Mexico. Other LCFS-type schemes that assign obligations to producers and importers have successfully achieved the CTP's objectives in a manner that enables renewable fuels to be
Ms. Savidanes, would you slow down, please?
Sorry. In a manner that enables renewable fuels to be cost competitive with petroleum fuels. Blenders, dispensers, and retailers buy fuel in New Mexico. They do not control the characteristics of New Mexico's fuel supply. Refiners and importers who transport fuel from out-of-state refineries and terminals to in-state retail stations do control such characteristics. If fuel retailers were to generate deficits, their ability to satisfy their obligations would be dictated by their upstream counterparts, who would have the leverage and incentive to raise prices. The resulting price increase would be passed down to consumers via higher prices at the pump. Including fuel retailers as deficit generators would also result in unnecessary administrative complexity for New Mexico officials. There are substantially fewer refiners and importers of fuel today than there are retailers. Thus, New Mexico's ability to ensure that all deficit generators are compliant with their CTP obligations is relatively simple and straightforward if confined to fuel producers and importers. New Mexico should also implement its implementing regulations or amend its implementing regulations to exclude co-processed fuels from credit eligibility under the CTP. Co-processing refers to the simultaneous transformation of biofuel feedstocks and petroleum distillates in conventional refined fuel. Unlike standalone biodiesel or renewable diesel production, co-processing does not add new refining capacity or increase the domestic supply of renewable fuel. Rather, it subsidizes existing petroleum refining operations and allows refiners to commingle small amounts of renewable inputs with crude oil streams, yielding a product that is chemically indistinguishable from petroleum fuels. This commingling prevents any transparent tracking of renewable content through the fuel supply chain. As a result, co-processed fuels are priced the same as petroleum fuels, eliminating the ability of consumers to benefit from lower cost, lower carbon products. These considerations are not exhaustive, and there are a variety of other factors that could decisively influence the success of New Mexico's CTP. That said, Double ACE is eager to lend our experience as New Mexico continues to implement the CTP, and we would welcome the opportunity to further discuss these issues with you at any time. Thank you for considering our perspective, and I'm happy to answer any questions.
Thank you, Ms. Sevedanis. You were a little hard to hear for some of us in the hearing room, although I understand the platform folks could hear you clearly. Would you be willing to send your written comment to the board administrator so that she can include it in the record as it's written?
The written version of my oral comments, just to make sure, because we also had submitted written comments as well to the portal.
Version of the oral comment? Yes, written version of the oral comment, yes.
Yes, absolutely.
Thank you very much. Her name is Pamela Jones.
Yes, ma'am. And sorry about the technical issues.
Thank you very much. Let me ask if there is anyone else on the platform who would like to offer public comment at this time. There will be other opportunities. Oh, Member Bitzer?
Yeah, I wanted to get the public comment person there, Teresa, to explain the group that she represents again. I didn't catch that.
Member Bitzer, I'm sorry, I didn't hear you.
The last commenter, could she explain who she's with?
Oh, yes, please.
Absolutely. So the name is Americans for Affordable Clean Energy, and we're comprised of fuel retailers and distributors.
Americans for Affordable Clean Energy. Thank you.
Yes, sir.
Thank you. Anything else? Any other public commenter? Any other questions of this public commenter? All right, thank you very much, Ms. Sevedanis and Member Bitzer. We'll go back to the technical case. And as the department witnesses are taking their seats at the table, I have just one thing to address that came up over the lunch hour, which is I understand that some folks may be making and or downloading some kind of AI transcript from the platform. And I just wanted to remind everyone that an AI transcript is not going to be the official record of this hearing to the extent there is an official record, and that record is being made by our fine court reporter, David Lee. Nothing else is official, and to the extent you plan to submit post-hearing submittals with proposed statement of reasons for adoption of the particular proposal you're offering, you will need to be making citations to the pages of the official transcript or to the exhibits. So please just understand that that might be useful to you in other ways, it won't be as useful to you as we go through this proceeding. So,
Carol Lynch has her hand raised.
Ms. Lynch?
Yes, I just wanted to bring it to your attention, Miss Hearing Examiner.
Ms. Lynch, I'm sorry. I'm having real difficulty hearing anyone on the platform. Would you speak way up?
Yes, is this better?
No, I'm going to wear a headset.
Put it up to your ear because when you start speaking, you're going to hear yourself through that.
Okay.
So when you're listening to them,
Okay.
flip
This
over.
one? Sorry.
So if you hold it like this,
Like that. Okay.
and then when you speak, take it off.
Thank you. Okay, I'm sorry. Please repeat
this
what you were
better?
saying.
Can you hear me? Can you hear me now?
Yes.
Okay. I did just want to bring it to your attention and the board's attention that it is required to seek consent for the use of AI, and that every party involved needs to consent. I don't know where the AI is coming from, but considering that this is a formal matter, I highly suggest that folks consent, and if consent isn't provided, then AI cannot be used. Thank you.
All right. Thank you, Ms. Lynch. What she said is that it's her understanding that everyone's consent is required in order to generate an AI transcript. And I have to say, this is not my area of law. I can look into it. In the meantime, there are both logistical, I guess, and legal questions here. One is, I'm not sure whether each person's personal computer generates that AI or whether it's a toggle switch on the WebEx meeting information that allows folks to do it. Let's take Ms. Lynch's warning into consideration. And again, please don't share AI transcripts, even if you've made them on your own computer. And again, please understand their limited use. At this point, I don't know what else to say. Would anyone like to comment or respond to that point? No? Okay. So we're going back to the Bureau panel. We do need to release Dr. Murphy by 4 p.m. Let's see, as I understand it, Mr. Noyes had completed his questioning, and we'll move then to Ms. Tremblay. Ms. Tremblay, I understand you're on the platform.
Hello, I'm not planning to make any specific comments right now, but I'm going to hold them for public comment tomorrow at 1 p.m., if that's okay.
Thank you very much for that clarification, Ms. Tremblay. I'll call on you tomorrow at 1.
Thank you so much.
And actually, at this moment, I'm only asking if you have questions of this department panel.
No questions at this time from Southwest. Thank you.
Thank you. We'll move then to Mr. Weatherby. Mr. Weatherby, do you have questions of this department panel?
Yes, I do.
Please go ahead.
Thank you very much, Madam Hearing Officer Orth.
Hold on, Ms. Sona. Ms. Sona has something to say.
Madam Hearing Officer, given the challenges we've had with the online platform and the lengthy 2 days these witnesses have been testifying, it'd be really helpful if Mr. Weatherby could be on camera so they can see him as well as hear him to try and decipher his questions.
All right, Mr. Weatherby, if you can turn on your camera, it might help avoid stepping on the end of one another's sentences, for example.
I would be happy to, but my camera is not functional.
All right, please start with your questions then.
All right, thank you. And I will go slowly. Um, the first question I have for Mr. Vaughn, if I would like to go to Mr. Vaughn's initial testimony, and let me find that here.
Hold on, Mr. Weatherby. I think we need to get Mr. Vaughn a headset.
Okay.
All right, go ahead, Mr. Weatherby.
Thank you very much. Good afternoon, Mr. Vaughn. Thank you for taking questions today. At the outset of your presentation, you indicated that you were hired, I believe you said, in September of 2023. Is that correct?
That's correct.
And when you were hired, were you hired specifically? I know it says that you're working as a rulemaking and strategic initiative specialist. Was that the initial reason you were hired?
I would say so.
Okay. And were you brought on board at NMED primarily to focus, or it was the matter before the EIB right now, was that the CTFP? Was that the first matter you worked on?
No, I was not brought on for the exclusive purpose of a rulemaking effort for exclusively the CTFP. As I have stated in my qualifications in my testimony, including in my resume, I have also worked on other initiatives, including other rulemakings that would include the new motor vehicle emission standards, for example.
Were you involved in the process of the legislation? Did you provide testimony or assistance to the department when the legislation was being heard before the House or the Senate?
I was not involved in the statutory lawmaking process.
Okay. Were you aware that it was being entertained by the legislative body?
I was.
Okay. And when you were hired, were you hired by the secretary? I realize the department hired you, but were you interviewed by the secretary and or senior staff at NMED?
Objection, Madam Hearing Officer. This question bears no relevance. It's completely irrelevant to this hearing.
Mr. Weatherby, where are you going with this line of questioning?
I'm trying to set a foundation, Madam Hearing Officer, to establish the direction that staff has been given relative to the development of the rulemaking. And if it came, I guess maybe what I can do is rephrase the question. I wanted to understand if those involved in developing these rules for the department were directed to go in a particular, to take a particular direction in the developing of these rules. And I do think that's relevant. As in any rulemaking, there's an element of focus on
Objection, Madam
science and-
Hearing Officer. This is moving into testimony.
So I do understand the point of the question, Mr. Weatherby. We can go a little ways down this path, but I'm hoping that it's not necessary to spend too much time on this. I think we heard from Ms. Borchert quite a bit about the rule development and their desire to carry out the statutory mandate. But Mr. Vaughn, if you have something to add to the testimony we've heard about what direction the team of rule developers led by you might have been given in developing the rule, you can add it now.
Thank you.
Thank you, Madam Hearing Officer. What I would have to say here is that our rulemaking team has truly been guided by science and the statute. We have not been directed by anyone to perform any particular outcome in this process. Many of us are indeed scientists ourselves, and we have followed the science and we have followed the statutory directives to produce this rule.
Thank you. Mr. Weatherby.
Thank you very much. Thank you, Madam Hearing Officer, and thank you, Mr. Vaughn. I want to make clear that I'm not suggesting that anything untoward on the part of the development on behalf of the staff, but maybe we could look at the organizational structure of NMED. During the process of developing these regulations, it's been laid out pretty clearly in the testimony and in the exhibits submitted by Mr. Vaughn that the secretary actually chose the individuals who are on the advisory committee. Is that correct, Mr. Vaughn?
Consistent with the statutory mandate, the secretary did in fact select the members of the advisory committee.
And can you explain if there was any communication from the secretary or any senior staff to you or anyone else as to who the secretary might like on that committee?
The secretary, of course, gave us a list of the 31 members that were ultimately appointed to the advisory committee.
Was there any discussion prior to his making his choice as to you? Well, I'll rephrase this. I believe you testified that the department reached out to the community at large for participants. Was there any direction given by the secretary or anyone else as to who should be made sure to have been included in that request for participation?
I do not recall if those conversations were held, but what I can say is that ultimately the press release we issued, which I do reference in my testimony and is included in my exhibits, went out to the general public. And so in that regard, the public was notified and it had a general opportunity to apply for a position as a member on the advisory committee.
Were there any parameters that you or anyone that you worked with were provided with as far as the development of the press release or any other effort to reach out to potential candidates for the committee?
I'm not sure I understand the question, Mr. Weatherby.
So were you the person who was primarily involved in the development of the communications to the public and any solicitation of potential candidates?
I was involved in helping to write the press release that we issued, but ultimately that press release is a product of our communications office within NMED, and the secretary directly oversees that office.
Okay. Can you give me a sense of the organizational structure of the leadership of the department as it relates to this rulemaking process? You mentioned that you were the project manager. Ms. Miano has also indicated that she had a general overview of the process. Can you and your colleagues that are NMED employees who testified the last couple of days with you are all involved in that process. Can you give us a structural sense of who communicates and kind of top down where instructions come from as to scheduling, as to who comes in to provide you advice, things of that nature?
Objection, Madam Hearing Officer. I really don't understand the relevance of this question. The roles and positions of the witnesses have been very clearly laid out. This is covered in the written testimony in the exhibits.
So, Mr. Weatherby, each of the witnesses has been very clear about their role in the rule development. We still have 4 more department witnesses who will describe their role in the rule development. We heard that Ms. Miano is the director, Ms. Borchert is the bureau chief, Dr. Murphy was a contractor from UC Davis. I mean, we've heard all of this. I'm wondering what your real question is, I guess, having heard from each of the witnesses what their role is.
Well, I believe most organizations, Madam Hearing Officer, have an organizational structure which defines who basically reports to whom. And that's the structure that I'm trying to find out as it relates to the development of this rulemaking.
Madam Hearing Officer, in response to that, I'd offer that this is outside the scope of Mr. Vaughn's testimony. He could testify to who he reports to, but he can't provide the entire NMED organizational chart in this hearing.
That's fair enough. That actually helps me, Madam Hearing Officer. So I guess I would rephrase the question. Mr. Vaughn, who did you report to?
The bureau chief, Claudia Borchert.
But you were the project manager, is that correct?
That's correct. I have run the day-to-day operations of the rulemaking effort.
Okay. And would that include the communication with the advisory committee?
I did, in fact, communicate directly with the advisory committee members. Other members of my team also directly communicated with the advisory committee members. Most of those communications were about logistics on how to access the advisory committee meetings in person or how to access those meetings virtually, that sort of thing.
Okay. Were any of the advisory committee members contractors with the department?
You're asking if the advisory committee members were under contract with the department?
Yes.
I think that's outside the scope of my testimony. I couldn't possibly know the answer to that question.
But you are the project manager, is that correct?
Objection, Madam Hearing Officer.
Right, Mr. Weatherby, he said he doesn't know. So that's his answer.
If you can provide me a moment, I'm pulling up a record that I wanted to look at, that I'm hearing officer, and ask a question about it.
All right.
Okay. Mr. Vaughn, were you aware that Adelante Consulting was a contractor with the agency, either before, after, or during this? Does that help refresh your memory?
Adelante Consulting did earn a contract with the Environmental Protection Division of the New Mexico Environment Department, which is where the Climate Change Bureau is situated. That contract was earned after the advisory committee was dissolved.
Okay, so and what was the purpose of that contract?
To produce NMED Exhibit 75, which documents some of the potential local economic and job impacts across the state, and also evaluates some of the non-greenhouse gas environmental effects potentially of this program.
Madam Hearing Officer, I would just like to state for the record that we have a witness that is going to discuss this exhibit that Mr. Vaughn mentioned, and it is not yet admitted into the record.
All right. So, Mr. Weatherby, if you're going to be exploring Exhibit 75, there'll be another witness doing that.
All right. Well, thank you. But we have established that Mr. Vaughn has worked with each of the 31 members of the advisory committee. Is that correct, Mr. Vaughn?
I, again, helped coordinate many of the meetings. I helped coordinate the logistics and the day-to-day operations of that advisory committee.
Okay. Do you know the date of the dissolution of the advisory committee?
I believe that information is contained in my written testimony.
Could you explain to us why it was dissolved?
I have done so in my written testimony.
Okay, you're familiar with the statute that created this rulemaking process, is that correct?
Yes.
Do you have it? Is it accessible to you at this point? Can you pull it up with I have some questions about that I'd like to.
While I am familiar with the statute, of course, this is outside the scope of my testimony.
Well, why would you consider it outside the scope?
Objection, Madam Hearing Officer. Counsel or Mr. Weatherby has not asked a question yet and is being argumentative with the witness.
Right. So,
Okay.
Mr. Vaughn, I understand that not all questions about the statute would be something you would testify about, but we haven't heard Mr. Weatherby's question yet.
Sure.
All right. So,
So-
Mr. Weatherby, go ahead and ask your question.
Okay. The statute calls for the secretary to convene an advisory committee. And that advisory committee is supposed to provide input and presumably recommendations in that process, and then to also review it as this evolution of a rulemaking process takes place and eventually gets adopted and eventually gets looked at down the road. Is that a fair assessment of what that committee is supposed to do, Mr. Vaughn?
The statute does say that the secretary shall convene an advisory committee, and I'm paraphrasing, to provide input. Yes.
Does it not also say that they have a life after that input is provided?
Objection, Madam Hearing Officer. The question calls for a legal conclusion.
So I think, Mr. Vaughn, if you can answer it as someone who is tasked with leading the project, do so. I will caution everyone on the panel again not to provide a legal bit of advice.
I would also like to ask Mr. Weatherby to repeat the question. I was unable to hear it.
Okay. I'm trying to. Okay. I would ask you, does the committee have a life after, under the statute, after the rule has been created?
Have a right? Is that
A life,
did I hear that
life,
correctly?
A life.
Does it have a life? Responsibilities?
Yeah, I should caution that I'm not an attorney here, but I do think that the final word in the clause that you are referring to states periodically review program rules, and it does not say, for example, to periodically review proposed program rules. And my understanding is that those are two different definitions.
Is your understanding that it's two different committees?
Objection, Madam Hearing Officer. We're delving outside the scope of Mr. Vaughn's testimony, which was about the initial meeting of the advisory committee, as we've heard testimony about from Ms. Borchard, in the manner that the advisory committee is addressed in the rule. That's her testimony. This is not Mr. Vaughn's scope.
Right. So, Mr. Vaughn, if you believe an answer would be helpful here, please offer it. If it really is outside the scope of what you came here to testify about, please say so.
Yeah, I would say that this question is outside the scope of my testimony.
Mr. Weatherby.
Okay. All right. Then let me pursue it this way. Were you responsible for letting the committee members know that their job was done and that they were no longer going to be a committee?
If I recall correctly, I do think I'm the person who sent out the dissolution letters. Dissolution letters being that the committee was dissolved.
And who made the decision to have the committee dissolved?
I don't know the answer to that question.
Do you know the answer to this question? Were you asked to send that communication out by the secretary?
Again, I don't know the answer to that question.
Well, who did ask you to send out the notification that the committee would be dissolved?
As I have testified to here today, I do take my direction from the bureau chief.
Are you saying that the bureau chief is the person who directed you to dissolve, let the committee know that they would dissolve?
Objection, Madam Hearing Officer. The question is reframing the witness's testimony to mischaracterize it in an intimidating manner.
All right, Mr. Weatherby, you need to accept the answers that Mr. Vaughn is offering. I believe he is trying to answer your questions.
Well,
Do you have other questions?
I do, and bear with me. I'm sorry that this is uncomfortable for some folks, but there are issues currently relative to rulemaking that at least have raised questions in the public's concern about how orchestrated rulemaking might be, and I'm seeking to find out if there was direction from anyone in particular within the administration. We've heard that.
Madam Hearing Officer.
I'm trying, Your Honor.
I understand that Mr. Weatherby is trying to explain his line of questioning. However, this is delving into testimony, and he needs to simply just ask a question.
Okay.
I didn't hear your last couple of words, Ms. Sona.
I think I said he simply just needs to ask a question.
Yeah. Mr. Weatherby, you have, let's see here, 5 minutes left with Mr. Vaughn. So I think the more direct you can be with your questions, the better.
Okay. Mr. Vaughn, did you meet regularly with the secretary regarding the rulemaking process?
No, I would not characterize it as regularly. I did meet with the secretary on occasion.
Did the secretary provide you with direction?
Objection, Madam Hearing Officer. Asked and answered.
Mr. Weatherby, I think he has answered that question already.
I guess maybe what I should be asking is what specific type of direction did you receive from the secretary?
Again, Madam Hearing Officer, Mr. Vaughn testified to this.
I don't recall he answered a question to that nature.
No, I don't recall that as well, except for your previous question was about the dissolution of the advisory committee. So perhaps the question would be, having set that topic aside, was there other direction you remember receiving from the cabinet secretary?
What I can say is that the department has a chain of command. I take my direction from the bureau chief.
Okay, and we'll have questions to the bureau chief regarding that. The last question is: as far as you know, Mr. Vaughn, was there any effort made to seek participation in the rulemaking process by any medical doctors, people who might be able to inform the rulemaking process as to the importance of this proposed regulation in relationship to public health?
I do not recall there being any medical doctors who applied to be on the advisory committee, although I would have to double check the records to be sure about that.
I could not find any in the information, and I do want to compliment you on a very thorough presentation of the meetings and the different participants. I could not find any. That's why I'm asking this question. How about any respiratory specialists?
Again, I do not recall anyone having that particular expertise applying or not applying for the committee.
Okay. I have a couple of questions for Dr. Murphy. Dr. Murphy, can you hear me?
Yes, go ahead.
Oh, okay. You mentioned in your testimony that you actually came on board a little later than what you were expecting because of a SNF of some sort between the state of New Mexico's contracting and I think your employer. Is that?
Yes.
Can you explain what that was?
Objection, Madam Hearing Officer. I'm not sure what the relevance of this is. And I do apologize for objecting so much, but we have 2 hours left of Dr. Murphy's time. And the parties have had 2 days with this panel, and the board is going to be forced to limit their questions. And I do think that is fundamentally unfair.
Mr. Weatherby, I'm wondering about the relevance of this question.
Well, I'm getting to a couple of questions relative to the contract. First of all, I wanted to know if the contract has, if what the scope of work, what were the deliverables on the contract?
Okay, that's a fine question. Go ahead, Dr. Murphy.
The scope of it's to provide technical assistance, to provide input, to be available to answer questions. Really, because our research group and myself in particular have done a lot of work with research and engagement on these topics, they wanted to have us available to help decipher the complexities and provide a perspective on how these have worked in the past.
And was the scope of work laid out with specifics and deliverables?
We didn't have specific deliverables. It was largely to provide access and to give myself and my colleagues the time to be fully forthcoming and to take time to explain things, or in some cases to go and look things up on our end that we couldn't do if we didn't have a contract in place. The ITS Davis, we do provide guidance to any member of the public or any institution that asks for them, but there are limits, and given that there was a rulemaking and a number of questions, we wanted to make sure that we had the time to commit to giving full and comprehensive answers.
Could you provide a copy of the contract for the record?
Objection.
Ms. Sona, it would be a public record, right? And available to Mr. Weatherby through an IPRA, for example, yes?
Correct.
If this is a matter of public record, it would be available under an IPRA.
All right, Mr. Weatherby, you might want to prioritize your questions here.
Well, Madam Chairwoman, wouldn't it be appropriate for a document like that has bearing on the reasons for Dr. Murphy to have participated in the rulemaking process? I mean, so many other documents have been entered voluntarily into the record. I don't understand why a contract that described what his role in the rulemaking might be one would have to go through an IPRA process, which obviously there could take a considerable amount of time depending upon how quickly the department decided to respond to it.
All right, so Mr. Weatherby, the board will have to deliberate based on the evidence offered by all of the parties, including NMED. As I understand it, it doesn't sound as though Dr. Murphy's contract is in the evidentiary record. And let me ask if you have other questions. I'm not going to compel the petitioner to provide a copy of that contract. Do you have other questions?
I do, not of Dr. Murphy. But thank you very much, Dr. Murphy, and thank you for assisting in the rulemaking process. The last questions I have, they're not that many, but I wanted to, several people asked yesterday about the number of employees that might be needed, new FTEs that might be needed for the implementation of the new rule, assuming it gets adopted. And I'm a little confused as to whether Dr. Rasso or Ms. Bochet, and I apologize for the pronunciation, you both spoke to the issues of staff at one point, so I don't know who is the right person to ask these of.
All right, Dr. Rasso or Ms. Borchert, who is the best person to answer, or do each of you need to provide a part of that answer?
Hello, yes, I'll take that question. How many FTEs do we expect for this program? 6 to 8 full FTEs.
Okay. And is there, you met, the way the questioning went yesterday was kind of like, well, we're sure we're going to be able to get them. Has the department discussed any of the potential jobs that are going to be needed to enforce the rulemaking with the Legislative Finance Committee?
Could you repeat your question? You were hard to hear.
Yes. Okay. Okay. Is this any better? Can you hear me now?
Yes, I can hear you.
Okay. So typically by now, the executive branch, with the exception of maybe the Human Services Department, have submitted their proposed budgets for the next fiscal year. And this particular rule, I believe you said, was going to be, the goal was to implement it beginning in July of 2026. Have you included these FTE positions in your budget that was submitted to the DFA, the Department of Finance Administration, and to the Legislative Finance Committee?
Yes.
And so did you submit a specific number of
Objection, Madam Hearing Officer. The relevance of what was communicated to the legislature is not relevant here.
All right.
Well,
I'm going to let her answer that if you have an answer at this moment.
The Bureau has a $5 million special appropriation, 2-year special appropriation, and these positions are paid from that.
Are you aware that, are you familiar with the organizational listings report that each agency submits and is collected and published every month?
I am.
And do you know how many vacant positions exist at the the Environment Department at this time, or approximate number of vacancies?
Objection, Madam Hearing Officer. I can't find the relevance to this hearing.
If I'm trying to speed it up, Madam Hearing Officer, these are the last couple of questions. The reason I'm asking this is there is a history, if you look at these numbers, of a very high vacancy rate at NMED. And the whole purpose of a rulemaking is that it ultimately will be implemented. And I'm trying to find out whether there is a serious commitment to the development of this rule, which would be reinforced by whether there is specific language in the budget and if in fact they're able to deliver on filling the positions. And this has been an ongoing problem with NMED, and it is relevant to what's going to happen here.
Okay, thank you, Mr. Weatherby. I'm just going to ask Ms. Borchert to address your question in a way that relates to this proposed rule and not to department vacancies generally. Go ahead.
Understood.
We are committing to filling the positions as expediently as we can to support this the implementation of this rule, which should happen no later than July 1, 2025.
Okay. Thank you very much. Those were the extent of my questions, Madam Hearing Officer.
Thank you very much, Mr. Weatherby. Let's see, I think I can put that down. So we have Dr. Murphy for just 2 hours. And of course, that 2 hours is going to include a 15-minute break at some point. Ms. Sona, let me ask if you have redirect, either generally of the panel or if you want to start now streamlining vis-a-vis Dr. Murphy, we could do that.
I don't think that one's on yet. Thank you, Madam Hearing Officer. If it's okay with you, I would like to reserve my redirect until after questions from the board. I believe it'd be most efficient because I can redirect Dr. Murphy virtually tomorrow should that become necessary.
All right, thank you very much. I was going to start at this end of the dais.
Actually, I had an opportunity to ask questions yesterday. So if you want to start on the other end of the table, that would be okay with me.
Member Garcia.
Thank you, Madam Hearing Officer, and thank you, panel. I appreciate your perseverance and especially all the work that you've done to prepare for this hearing and the rulemaking in general. I know it's a lot of work. So my question is regarding the rollout of this process or the rule. I know you're having to build up your DMS system. Is that with existing equipment that you have? I think you mentioned you have a contractor, IT contractor. I might have got that wrong. I just was wondering about the logistics of that DMS system.
Right. So the data management system is not too dissimilar from other data Can you not hear me very well?
Let me
if I speak up louder, does it help? Or do you still want the headphones?
This works.
Okay. The data management system is, of course, suited to this rule, but it is not in logistics that dissimilar from other data management systems that the department operates. We're basing that, I believe, as I talked about yesterday, maybe. It's based on code that was first written by IT staff at the California Resources Board in 2009. So we've been going for the last 6 months or so through a pretty significant process with our IT contractor of updating the code to modern requirements to be able to run it on the department's systems. There's also a few peculiarities of our rule that are different than California's that will require adaptation of that system. But the brunt of the work is over, which was taking 2009 code and making it suitable for modern systems. Did that answer your question?
Yes, it does. Thank you. Thank you very much. My next question is, I know it's going to take a while for, the industry, or rather for the market, to sort of catch up with the rulemaking. And I think I heard somebody testify, it might have been Director Miano testify, that the electricity sector would be probably the one that would create the most credits initially, right? And so, maybe thereafter would be the one that creates the most credit for the market, right?
Yeah. Yes, I think that electricity will be a significant credit generator from the beginning of the program, and only more so as time goes on.
Okay. And do you anticipate that there would be adequate credits initially for the deficit creators, such as the oil and gas industry? For the deficit creators, do you anticipate there would be adequate credits so that they won't be out of compliance in the first couple of years?
So the department has done an entire fuel market modeling exercise that the next panel is going to talk about.
Okay. Okay, great. And I know you anticipate that there will be future amendments, adjustments to the rules, and I know you want to minimize that as much as possible. One of the parties, I forget which one, suggested in light of what California went through, the rule has a provision for deferment, but I understand that's only going to be used in extreme circumstances, extreme events affecting the market. So California used an automatic acceleration mechanism. Did you look at possibly using that? Whoever can answer that.
Yes. I mean, while we were developing our rules, California had their proposed rules out about the automatic, what does the second A stand for? Acceleration mechanism. So we were definitely tracking their use of this and considered it. It is a tool that seems especially useful after a couple years of the program, because the purpose of them having that is to essentially have a way to even out, to make use of the bigger pool of credits, right? We're not in that situation yet, where we know that we have a big amount of credits. When you have a large amount of credits, the price for those credits is usually lower. And it also indicates that the market is not saturated, and it could indeed have a more stringent or a lower CI value. It doesn't feel quite ready for our infant program. Certainly would be on the table for the next update.
And just to add one thing to that, Ms. Borchard is correct. The auto acceleration mechanism is needed if you have an oversupply of credits. It took a number of years. The auto acceleration mechanism, is needed if you have an oversupply of credits. It took a number of years for that oversupply in California to build up. And so, it's unlikely that it's difficult for me to think of a market condition that would exist where you would build up that big of a supply of credits where an AAM would be needed in the first few years of a program.
Okay, thank you. Also, I was wondering, aside from the electricity sector providing credits, what industry do you see coming into New Mexico first, or what would we see first starting to be developed in New Mexico in terms of industry? Would it be, yeah, go ahead.
I will give a high-level answer, and then I also recommend that you ask the same question of our economic panel. Starts tomorrow, or starts whenever we're done here. There are a couple other generators that will also start, which is ethanol, right? Ethanol is already part of the supply mix, and we expect more ethanol to come. We actually know that there's an ethanol plant moving to Portales, New Mexico, so they will also have a lower, and the process they're using will result in a low CI. So I imagine there'll be quite a few credits from ethanol. And then renewable diesel as a drop-in fuel, we expect credits from renewable diesel as well on the onset. And then as to the rest of the supply mix, I would defer that to the economic panel.
I actually have one thing to add here, which is we've spent a lot of time today talking about biomethane. And I wanted to let the board know that we have about 300 compressed natural gas vehicles in New Mexico. So I don't think we expect that to be a major fuel in New Mexico.
How about hydrogen? Do you see that being developed because of this rule, or sort of being incentivized because of this rule?
I think this rule probably does incentivize both biomethane and hydrogen. I think there is kind of an open debate in industry because all of these vehicles we're talking about with compressed natural gas vehicles and hydrogen vehicles, as well as electric vehicles, have a separate drivetrain. They're not drop-in fuels. I think their industry is somewhat split on what technologies they feel it's best to adopt based on their individual business practices and the needs of their vehicles. I think we may have one hydrogen vehicle that's registered in New Mexico, and I'm not confident that it's actually in New Mexico. And I don't believe we have any hydrogen fueling infrastructure currently in the state. So certainly there's a lift there for any industry that wants to start using hydrogen as a transportation fuel in New Mexico, that they have to get that infrastructure in place.
Okay, thank you. And one more question, probably for Ms. Borchert. Listening to a lot of the questions in the last few days from various representatives from industry, I get the sense that a lot of folks are really trying to understand how exactly this is going to work and how it's going to impact them, of course. But it sounds like they're really trying to understand how this is going to work. And so have you considered, I know there was the advisory committee and stakeholder meetings, et cetera, to gather comments about the rule and what they want or don't want in the rule, et cetera. But have you considered some kind of workshops to give instruction on how different parts of the rule would work? I know there's going to be written guidance and a lot of administrative guidance, but sometimes it might be efficient to rather than getting a lot of phone calls and answering a lot of questions, it might be more efficient to have workshops over particular areas where folks are having a lot of difficulty in understanding what they're supposed to be doing and how it's working.
Thank you, Vice Chair and Member Garcia. First, I just want to say that, we've been working on the Clean Fuel Standard 4 years in a row in the legislative process, right? It passed March of 2024, so that's over a year and a half ago. So while there undoubtedly are people who don't know, because maybe they're more localized to New Mexico, how it works, most of whom this impacts are industries that already participate in California, Oregon, and Washington. So yes, our system will be slightly different, as Dr. Rosso explained. And absolutely, we will, I just witnessed Dr. Rosso roll out what's called the large entity reporting, which was a requirement. And I think they had 7 workshops in order to get people to register, right? So I am confident, and I can even promise it, that we will do what we need to make sure people understand the timelines, how the system works, both in generalized workshop formats, as well as then following up individually as needed. We want people to register, right? There's no point in having a program if we don't get people to register. I'm not quite sure. I'm convinced that people don't know about it. You might be hearing that. I would just not be sure if that's true.
Okay.
I'll just expand a little bit on those workshops. So for the large entity reporting requirement, I held both 2 webinars where I presented information on how to register. And then we held weekly, what I called office hours, So it was an open Teams call with a link on our NMED calendar and announced via listserv and on our website, where we encouraged people to show up to our Teams call and share their screen to show us the problems they were having and work through getting those reports in and any questions they had about that reporting requirement.
Great, I appreciate that. Thank you very much. That's all my questions for now.
Thank you. Member Ely.
Good afternoon, esteemed panel. Good to see you. A few questions. One on the deferral process, kind of following up on what Member Garcia said. Do you know of any jurisdictions that have implemented the deferral process, either through an emergency provision or forecasting? And if so, what were the circumstances around that?
I'll pass it to Dr. Murphy in a second. We did talk to Washington, who said they had, even in the last month or two, used the credit clearance market component, which I think of it as part of but not as a result of deferral, but rather as a way for parties who had not been able to meet compliance by obtaining credits that they needed to demonstrate compliance. And so the credit clearance market was opened up and used successfully to satisfy those regulated parties that had not gotten their credits through a different process. And then I'll let Dr. Murphy answer.
Yeah, I would say there really aren't a lot of examples of deferral or sort of emergency override or safety valves being needed in the programs that have been active to date. There have been a few instances of credit clearance market activities going forward, but in most cases, they were for very small credit volumes, not indicating there was like a systematic lack of credits or inability to comply. In a few cases, it was companies who just fell asleep at the switch on the compliance paperwork, didn't get their stuff in, or went bankrupt and hadn't closed their account or things like that. Washington, during its sort of initial spin-up process, did run into some IT problems, which caused them to defer some reporting. And I have to go back and double check exactly the extent of it. They may have, I think, deferred some compliance, but it was because they were, their IT system was a little more problematic to get going than before, and that was sort of an early kind of teething problem that they viewed as resolved. But none of the jurisdictions that have annual fuel supply forecasts have had those forecasts encounter a problem or anything like that.
So you don't recall any circumstances in which the market went askew and they had to step in with an emergency deferral process?
No. The only kind of market sort of problem like that was in California, where there was an oversupply and the price kind of dropped below what is generally thought needed to support the kind of transition over the long term. But again, that's an oversupply problem, not a compliance problem. And no, there haven't been systematic compliance problems like that.
This may be directed to you too, Dr. Murphy. What are the costs of credits right now around in the, say, the West Coast states?
In California, I believe they're around $60 a ton. I'd have to go back and look at the most recent numbers. I think they're a little higher than that in Oregon. I am blanking on the Washington credit price right now. They are, I believe, higher in the BC program, but that's because the Canadian context is very different. The regulations are different, so it's not directly comparable in the same way.
So in those markets, it's not bumping up against the cap?
No, certainly not.
This is also directed at you, Dr. Murphy. I think it was in Cross. You said there was some maybe delays or bumps in the California market related to NOx emissions from the combustion of renewables. Could you expand on that just a little bit and explain what happened there?
Yeah. So I'm trying to figure out how deep down the rabbit hole of vehicle emissions to dive here. Certain types of biodiesel, not all biodiesel, and again, biodiesel is different than renewable diesel, but certain types of biodiesel, when they are burned in engines that lack an emissions control system, like those required by the 2010 EPA rule, so that have no selective catalytic reduction requirements, can slightly increase NOx emissions compared to petroleum diesel. And in the analysis that CARB did around one of the rulemakings in the 2010s, I can't remember if it was the program initiation or the first major rulemaking after that. I'd have to go back and refresh my memory. Essentially, it was viewed that they assumed minimal impact without sufficient demonstration and sufficient quantification of minimal impact, and they were instructed to go back and redo it. They did that, and after the quantification, I believe during again, I would have to refresh my memory to be certain, but I believe that in the process of redoing it, they had also taken into account the presence of NOx reducing fuel additives that could be added to those specifications to further help reduce that. The total NOx emissions, I believe, was pretty small, but it was non-trivial, and under the California Environmental Quality Act, anything that causes a net worsening of environmental quality, even if it's relatively small in magnitude, is a problem. So it was sort of a need to go back and correct that. But ultimately, it was largely a redo the analysis. It didn't require particularly substantive changes to the rule.
Okay, thank you for that. I won't ask you about NOx related to this rule. I think the next panel will address that. Yeah. And please, panel, let me know if this question should be redirected to ERG. But there is a requirement in 201 that the department review the carbon intensity values every 3 years, at least every 3 years. And one of the things that the department is to look at is some of the upstream oil and gas emissions. Did that analysis go into the current carbon intensity value for tables 1 and 2?
Let me find. Do you have, sorry, the section that is?
201B, paragraph 1A.
Right. So this provision applies specifically to tables 4, 5, and 9 in the rules. So that would be the lookup table, which is the carbon intensity for reporting fuels that are fossil fuels, as well as the temporary table, which is temporary for alternative fuels while they're applying for alternative fuel pathways, and table 9 is the indirect land use change values. So we did have ERG on our behalf conduct an analysis, and that was the OPG modeling, which was specific to PAD 3, the Petroleum for Administration Defense District 3. So it's specific to the fuel that is both imported into PAD 3 as well as produced crude oils that are produced in PAD 3.
So is that a yes?
Sorry, Member Ely. Yes, that's a yes. We did have ERG do a specific analysis.
And one of the reasons I ask is I know this board and Oil Conservation Commission passed rules the last couple of years to reduce VOC emissions and methane in the Permian or throughout the state. And there was a recent report that on the New Mexico side of the Permian, we are releasing about half of what the Texas side of the Permian is releasing. And I'm just wondering how that might be accounted for, but that may be in future rulemaking, or that may be more appropriate for ERG to respond to.
So I'd encourage you to also ask ERG about the OPG analysis and how those interplay. But also, I think this is a very complicated question because most of the crude that is produced in New Mexico is then exported to be refined in Texas, where it is then mixed with both crude from other states, Texas, Louisiana, mostly within PAD 3, but also international imports into PAD 3. So the effects of the ozone precursor rule for the oil and gas industry, as well as the methane waste rule from the Oil Conservation Division on the carbon intensity of transportation fuels in the state is a really complex topic.
Thank you for that. And I think my last question goes to, again, tables 1 and 2, and the glide path for the reduction of the carbon intensity between the beginning years and 2023. The later years seem like 1% per year to get to 2040 to meet the statutory requirements. But how did you come up with the percent reductions for each year between the initial years and 2030?
Thank you for asking this question. So we considered several different glide paths in between the initial compliance period and 2030. And one of those options we considered was a linear glide path, like it is from 2030 to 2040. Ultimately, we decided that it would reduce market effects, and perhaps the next panel can speak more on this, to have a more exponential type curve.
So it's slower in the beginning, fewer emission reductions required, and speeds up at the end. Perhaps, if this is correct, to help industry come up to speed without greater emission reduction requirements, or excuse me, carbon intensity reduction requirements right off the bat. Is that right?
You have that right on the nose, Member Ely. Yes, and another benefit of having that slower reductions in the beginning and higher reductions towards 2030 is the ability of the regulated industry to bank credits towards that 2030 goal.
That's all my questions for right now. Thank you.
Thank you, Member Ely. Member Bitzer, do you have questions of this department panel?
Yeah, just you really date back to yesterday when we first got started. I think one is to Bureau Chief Borchert, the CI carbon intensity. She had I think it was her that had a screen on the or a PowerPoint on the screen that had gas at 96.9 and ethanol at 69 point something. I didn't write it down in time before it came down, but and then I'm not sure if I saw it there or found it elsewhere, but corn was down at 29.1. If I'm not mixing apples and oranges on that. Is there anybody have a handy number about where natural gas would sit on that CI scale?
Thank you for that question. I'm going to pass that in part to Angela, but first I just want to say that what I didn't say in my slide yesterday, in part because I thought it was premature. Now you guys have learned a lot more. The CI values, which Dr. Russo will talk to you about in table 5, are temporary values, and the ethanol number that I had on my slide comes from the temporary value. In reality, every single ethanol that is brought to our state will get their own CI value based on the particulars of how that CI is measured, and that's why I didn't put that caveat when I talked. Very conscientious of my 30 minutes. But I'll let Dr. Russo talk more about your question.
Thank you, Member Bitzer, and thank you, Ms. Borchert. So as Ms. Borchert just said, I'm going to caution that the values I'm about to talk about are from Table 5, which are temporary fuel pathways, and they are intended to be both representative of fuels that are brought to the state, but also conservative in that we don't ever want the temporary values to be lower than the actual carbon intensity of the fuels that are coming in. But you wanted to know about natural gas. So fossil natural gas is in table 4, which is the lookup table. And under the department's proposal, they are required to always report under table 4. So fossil compressed natural gas has a carbon intensity of 74.3 in that lookup table. And then renewable natural gas or bio methane. Give me 1 second. Table 5 is quite long. We do refer to it as renewable compressed natural gas, and we actually have 3 values in the temporary table for renewable compressed natural gas or biomethane. For biomethane derived from anaerobic digestion of livestock manure, that would be 62.7 grams of carbon dioxide equivalent per megajoule. And when you do not account for avoided emissions, and negative 27.3 grams of carbon dioxide equivalent per megajoule when you do account for avoided emissions. And then biomethane that is derived from landfill gas or wastewater treatment gas has a carbon intensity of 21.4 grams of carbon dioxide equivalent per megajoule.
Hey, so the stuff that I drive a CNG powered Honda Civic that I've had for about 15 years, and I was always curious as to what the avoidance level more or less would be, because I'm sure I'm getting my natural gas the same place UNM is, because I use their pump. So it's a little better. It's not quite ethanol, but it's close. And certainly better than gas. Okay, that's kind of a cool bit of information.
Remember, Bitzer, you're one of the 300 people in New Mexico who has a compressed natural gas vehicle.
I was told when I bought, I used to work for a previous mayor, and I was kind of his green point man. And I told him my next car was going to be greener than a Prius, and I thought I was going to get a Chevy Volt, but they kept not selling them here because they didn't have anybody to maintain them. So I was talking to the Honda alt fuels guy out of LA at the time, and he had just moved here because his wife's a doctor who got hired at UNM. And so he said, "Well, if you want something greener than a Prius, get the Honda Civic GX. It runs on natural gas, and mile over mile down the road, you're about 10% greener than a Honda, even though it gets better gas mileage. It's still running on gas." So that pretty much comports with what he told me there, I think. But we're down to one station. The one real close to my office here off 98th Street in Albuquerque closed down recently. They sold LNG as well for long haul truckers. I'm not sure what the truckers are going to do now, but so it's sort of had its heyday. Maybe it'll come back under alt fuels incentives. But then I wanted to look at Dr. Murphy real quick. I did my undergraduate there on the West Coast as well. Moved to DC, but stayed involved in eco policy and followed it from a distance. And I remember the hydrogen highway coming out. It was going to be the next big thing. I think that was Governor Schwarzenegger era. But is that still a thing? And if so, is it a thriving thing?
So it's uncertain at this point. I would say hydrogen for like passenger cars and trucks probably doesn't look like it makes a lot of sense given the way that batteries have developed. Essentially, batteries offer equivalent range, lower cost, and same performance. There are some questions, and there's some spots in the kind of medium and heavy duty sector where hydrogen may have a role to play. The question is really, is there enough in that space to justify the kind of expensive building out the network of hydrogen fueling stations? Now, we do know that hydrogen is going to have a big role to play in a lot of stationary applications. It is essentially an ingredient or a component of fuel production. So it a lot of refineries will be using hydrogen, and if they can use lower carbon, green hydrogen made from electrolysis or biomass, that looks better. Certainly, there's also has a compelling case to say on energy storage and other stationary applications. The jury is kind of still out on hydrogen as a vehicle fuel, but I know there are a number of demonstration projects and companies that are working on that diligently.
As I recall, the technological challenge was the membrane. The fuel cell membrane doesn't react well to freezing, and I'm not sure if they ever engineered past that. I tried to lease a Honda Civic Clarity when they first started leasing them to folks living in Malibu and so forth. Never freezes there, so I've reached out, and they said, "Yeah, we're not going to lease you one." I opened an account with Matheson Trigas. They sell hydrogen in bulk to our competitive gas. We have the annual balloon fiesta here, and it's not all hot air balloons. Some of it's gas balloon competition, and everyone says they're using helium, but they're really not. Really expensive. But anyway, I had the account and everything, but then I couldn't get my hands on a Clarity. But did I have another question? Oh yeah, we were talking later about the July 1st, 2026 initiation of and having a application backlog. Wondering if that date comes to fruition, if y'all could maybe not take applications, but take pre-applications or preview, not review, but preview, so that folks, you're going to have a big glut at once, and this will be their initial bite at the apple. There's likely to be, especially you talked about the more complicated applications taking 18 months rather than a month or two. And I was wondering if you could give them maybe 3 months or 6 months head start to, one, refine their application process, and two, even out your workload a bit. I'm wondering if that's some sort of possibility, maybe.
Yeah, Member Bitzer, this is Dr. Rasso again talking about the alternative fuel pathway applications and what we anticipate. I think we were very careful while writing the sections of the rules talking about alternative fuel pathway applications to specify that we did not have to receive or process the applications in the order they were received, particularly because we don't want to cause a backlog for the more simple applications. So it's my intent to prioritize review of the simplest applications to get the fuels reporting into the market using the most appropriate carbon intensity as quickly as we can. I'm not sure that adding a pre-application process would significantly streamline that.
Okay. I just heard that there was going to be, heard y'all say that there was going to be a backlog. I was just wondering if you could ameliorate that in some way. Sounds like you're going to triage these applications is what you're going to do, so that folks who can be done quick aren't held up by folks who are going to take a long time anyway. That's all I've got. Thank you.
All right. Thank you, Member Bitzer. I think it's time for our afternoon break. Let's come back at 2 minutes to 3, please. What? We need a break. We have Member Hunker, Member Trujillo, and Chair Sweeney still to go. All right. Shortly before 3, please. We're back after a short break. Member Hunker, do you have questions of the department panel?
Yes, can you hear me okay?
You might be muted, Member Hunker.
No, I'm not muted. Can you hear me?
You're very soft, Member Hunker.
Well, okay. I will get as close as I can to the computer.
Thank you.
Okay. And for the record, we don't have a natural gas vehicle, but we are on our second Prius. So we're doing what we can. And thanks to the panel for all your great work developing this proposal. I have one question which I actually asked of Director Miano on Monday, and she said, ask the panel. So and that is, are there areas within the state where this rule will not be effective? And if so, does that complicate or does that add complexities to the implementation of the rule?
Madam Chair Sweeney and Member Hunker, this is I don't know if you can see who's talking, but it's Claudia Borchert speaking. Let me just make sure your question is, are there areas in the state where the rule does not apply? And New Mexico's, the Environment Department's state jurisdiction is limited to the parts of New Mexico that don't include sovereign tribal entities. So that would mean that those areas are not subject to the rule. I don't know to what degree Mr. Vaughn's oral testimony went into it, but his written testimony does describe the outreach that we did, the tribal engagement that we did, and we have not yet, I think he did cover it, had any of the 24 tribes, nations, pueblos that we reached out to engage with us. So it's hard to say whether, if they choose to engage with us, what kinds of complexities that will introduce into the program we are embarking on. And I think we have decided that indeed it will be very case to case, depending on the facts on the ground for any particular one of those 24 sovereign nations.
Well, I do know there is oil and gas production, at least on Jicarilla and Mescalero lands. And there are certainly a lot of gasoline retail establishments on tribal lands. So it'll be interesting to see if there's cooperation there or how that factors in.
Yeah, Chair Sweeney and Member Hunker, indeed, as I might have said earlier, we're going to be learning a lot about how fuel flows in New Mexico, and so the regulated party, being the importer or producer as in refineries. There's only one refinery in New Mexico, that's in Artesia. So from that perspective, we don't. There are no refineries on, as far as we know, on tribal lands. So, but where fuel gets imported and how it reaches the retailers of which you speak, it's not going to be the retailers that are going to be impacted, but anybody that provides fuel to the retailers. And we'll be learning a lot.
Okay, thank you. That's all I have.
Thank you, Member Hunker. Member Trujillo, would you like to go next? I don't see Chair Sweeney right now.
Thank you. And for time's sake, I'm going to keep my questions to a very narrow subject here. Most of my questions are around the credit system, the DMS. So I'm curious if you could help just kind of explain this to me a little bit better, so I have a better understanding of how is there an independent audit program for the DMS? I know you'd mentioned that there was a system of balancing the credits quarterly, but I was curious if there was an external audit of the credit system.
So there's not necessarily an external audit of the credit system. Both the credits and deficits are calculated quarterly, which I think might be what you're remembering. And it's a relatively simple formula. I had it up on one of the slides, and I think I certainly hope that regulated parties are paying attention to this and noticing if they think that that is incorrect. We'll certainly be spot checking those calculations, especially when the system first goes live. So there's not. Did I answer your question about that, Member Trujillo?
Well, what I'm really trying to figure out here is, I mean, if I understand correctly, real money is being traded.
So I think I see where you're going with this. Let me try to address it. So when regulated parties trade credits, that is reported within the system, and that's how the credits themselves go from one reporting party, a credit generating party, to say a deficit generating party, is they have to report it in the system. And the way that works is one party comes in and reports that the sale has occurred, reports certain information about the sale. The actual money doesn't trade within the system, it's just the credits. But that then has to be confirmed by the other party that's a member to that deal before the credits are actually transferred accounts.
Okay, so is there an opportunity, or has this been examined in any way to protect the system against fraud or corruption and trading amongst companies? I mean, call me pessimistic, but I just feel like if there's an opportunity to do something like that, somebody's probably going to figure it out. So has that been looked at?
I'm not aware of that happening in any of the states that have similar systems. I understand your pessimism. People take opportunities where they find them, generally speaking. I think so. First of all, only parties that are regulated under this rule, either as a regulated fuel provider or as an opt-in provider or as a what's called an aggregator, we addressed it briefly, can actually register in the system. So everyone who has the opportunity to report this type of transaction is already regulated under this rule, which somewhat limits the risks of that happening. In addition to that, as I mentioned, those credit transactions have to be confirmed by both parties.
Okay. Has there been, Dr. Murphy, did you want to add to that?
I was going to say the experience from other programs is, sort of fraud that happens within the system. Fabricated trades have not been an issue. Generally speaking, these systems have had, not a lot of issues with fraud. Where it has occurred is people reporting inaccurate information to generate the credits. So, claiming their process is cleaner than it is. Though that has also been more of an issue in the federal renewable fuel standard, which is different reporting requirements than most of the state programs. So there have been some, examples in state programs where credits were generated and then later found to be invalid because the facility operated in dirtier ways. This is why the third-party verification provisions were added in to try to protect against these issues.
Okay, yeah, and that's kind of where I'm kind of going with this and trying to understand it a little better. So the third party that's verifying, I guess I must have missed it somewhere. Who is that third party?
Okay, so there are in our rules at section 508 of the rules, most reports are required to be verified by a third-party verification body. So this is essentially an external auditing firm that comes in and looks at what's been reported to the department, either in quarterly fuel reports, an alternative fuel pathway application, or in the annual reports that fuel pathway holders have to file with the department. And the way that works is the regulated entity has to submit the report to the department. And after it's been submitted, they have to hire a third-party verification body, which, as I described, is kind of an auditor, who looks through the reports, audits them for consistency, in some cases makes site visits to the facility to look at what is actually happening on the ground. And then they submit a verification report to the department.
Thank you for helping me understand that a little bit better.
Oh.
And so just kind of following along this line, the credit clearance market, as I understand, they set the cap and they kind of regulate that. Is that how I understand it?
The credit clearance market, should it be initiated, does have a cap on the ton credit price of $270, and that gets adjusted annually by the CPI, the Consumer Price Index. And just to be fair, even though that cap is there, I don't think that it would be really unusual for that cap to be hit. It does also kind of move backwards into credit trading too, because it also signals that there's no point in buying a credit higher than 270 in the open trading, because if you can't get the credits you need, then you might as well kind of ask the department to have a credit clearance market so that that cap is in place. So it acts as a cap in the program, even though it's officially only in the credit clearance market. Does that make sense?
Oh, it does. And thank you. This isn't quite my bag, so I appreciate you walking me through this. Is there an independent mechanism that regulates the credit through that credit clearance market? How does that work?
So this is generally how it works. So the department, based on circumstances such as a deficit generator not being able to meet their annual compliance, could initiate a credit clearance market, in which case it asks for anybody who holds credits to pledge any credits they have. It's like opening up almost like an auction that says, this person needs credits. We're still not playing a role in that, but how can we help them get the credits they need? And then trading can happen. And then also, if nobody pledges any credits, then the department has the authority and the rule to be able to require that any credit holder of credits that are more than 5 years old pledge those credits. And also anybody who holds more than 10% of the total amount of credits in the bank pledge anything above 10%. And that's just meant to increase the amount of credits that are available for that auction, for the seller and the buyer to reach an agreement. We don't play a role in how much those interactions, those transactions go for in terms of the credit price.
Okay.
I would also just add that in the existing state programs, the vast majority of credits are not traded through the credit clearance market. They're just traded between parties. So a deficit generator establishes a contract with a credit producer. So, a refiner will contract with an ethanol producer or biodiesel producer or charging company to buy the contracts. That is handled between those two parties. They report the transaction so the regulator knows whose account the credits belong in, but all the specifics of the contract structure and price, they're reported, but they're set between the parties. The credit clearance market is really meant to be the emergency sort of mechanism if something unusual happens. There was concern in the early years for a number of these programs that with not many participants, not a whole lot of entities participating in it, it might be hard for somebody who needed credits just to find who's got them and to find the counterparty for the transaction. So part of the idea of the credit clearance mechanism was, if you can't find somebody, we'll make sure that we'll find it for you through this sort of special mechanism. And then it was also used to say if somebody couldn't obtain credits or chose not to, they just wanted to, flout the regulation for whatever reason, this would be a mechanism by which to say, listen to your regulated party, you have to comply. And this creates the structure for doing that.
And thank you for explaining that further. I understand there are, I've seen the enforcement portion of this, but is there a path for resolution if there's just conflict between two parties in trading credits?
That is a good question.
So I don't think that the department could resolve the conflict, but we do have the ability to go in and verify the credit. So one of the things we did think about is what if somebody's selling a credit that ends up being not valid, or maybe even that it was generated because of false information they gave us about the fuel that was generating that credit. So we do have mechanisms to be able to retract credits and have the buyer of a false credit basically be able to rectify that situation. I have to go back and read it. I remember working on it, but I'd have to go find that.
Okay.
So there's some assurances there around that.
Okay. Thank you very much. And that will be the end of my questions.
Okay. Thank you, Chair Serena.
Thank you all. And I was able to listen to most of the discussion, running back and forth outside there. I was listening from the back, but I wanted to go back to some of the previous questions under Ms. Miano's testimony. And I just want to, because I understood you might have more detail, and I think might be better suited for this. So I understand that, Mr. Murphy, you might have some, bring us some enlightenment of what's been going on in under similar rules or processes that other states have. As this program, or has those other programs gone forward? And I understand, I'm just getting an idea of how this works. We've talked about hypotheticals here and there throughout our conversations. So in those other programs in those other states, is there a point where, and I know they're structured a little bit differently, where they've started to really get their feet underneath them and are really taking off? And like I think you mentioned in earlier testimony that there's some possibly gearing up for new rulemaking because of lessons learned. Can you expand about on that? Because I'm just going back to the regular and frequent rulemaking comment that I had yesterday from Ms. Miano, or the other day.
Yeah.
What are other states seeing, and what is kicking off maybe that revision or that relook at and needing rulemaking in particular?
Yeah. So in general, these policies are meant to facilitate a fairly profound transition in the energy and transportation systems. And, we know a lot about how those are going to look. We certainly don't know everything. And given the dependence of policies like CTFP on analysis and modeling, to do the analysis and modeling, you got to put in assumptions. And then a few years later, it might turn out those assumptions were just not right. And so sometimes you have to update the analysis and assumptions. In a lot of cases, the way the analysis works is you're comparing what's happening to a counterfactual, right? To what would have happened without the regulation. And again, you have to assume sort of that world, and or you're comparing it to a business as usual case. And what is considered business as usual will change over time, right? The sort of default way businesses do business, or did business in 2010 in California when the LCFS there was first adopted, is not the way they do business in 2020 or 2025, and it's not going to be the same in 2030. And we know that the transition to new technologies is not going to be a perfectly linear sort of straight line. There's going to be technologies that will emerge suddenly. There'll be technologies that overperform compared to projections. For example, lithium-ion batteries have generally overperformed their projections of, their capacity, their availability. They have generally been cheaper than we projected, and other technologies will underperform them. So, because so much of the process of regulating a program like CTFP, even at the very high level of setting the right target, like I said in my testimony, you have to go and align the target with the capacity of your market to move. And your understanding of what that capacity to move is going to change over time. So you have to go back and adjust the targets, or you have to add in provisions to figure out how to account for technologies that were not part of your sort of worldview when the program was created. There's a number of other situations like that. In most cases, the programs that are out there go through major rulemakings about every 5 years or so. There might be minor ones, little tweaks to adjust one thing or another, but usually there's sort of fairly major ones where targets are changed, high-level targets are changed, or there's significant amendments. That seems to work reasonably well, but everyone's going to be a bit different. So yeah, I don't know if that answered the question. There's obviously a ton of complexity here. I also just would like to say, especially because I have to leave in 45 minutes or so, I am certainly happy to help keep providing information and providing perspective. We have a number of materials on our website which were not submitted as part of evidence here. As long as we're not violating any rules of ex parte communications, I'm happy to go and follow up with you directly afterwards to help with this. This is an extremely complex topic. I could probably fill the entire 2 weeks you had budgeted for this to just give you the top to bottom view on that, which would be fun for me. I don't know if it quite be the same for you. But yeah, if there's more things we can add, please feel free to reach out after today, and if I need to be online tomorrow morning, I should be able to do that too.
Yes, Mr. Vaughn.
Chair Serena and members of the board, I would just like to add that certainly less than a majority. I'm not sure exactly how many, but I do know that we've learned from other states that at least some of their rulemakings were initiated also as a result of changes to their statutes. And I just wanted to provide that as well.
Thank you for that. I have a lot of questions. I know you're on a tight deadline here to get to the airport. I think it's over. I overheard. But for you, Mr. Murphy, I had some other questions. So over the years of your work and you following this other efforts in other states, I guess I'm interested in the full understanding and analysis of impact of, say, new technologies. I know you have focused a lot on land. Sometimes we see unintended consequences and use of resources that might work in, say, California, but maybe not here in New Mexico because of different resource capacities and constraints and capabilities. So in your work, how has that helped to evolve the analysis of full impact of, say, a new technology?
Yeah. So I think one of the core strengths of the fundamental design of programs like CTFP, the LCFS and clean fuel standards, is the reliance and the close tie to life cycle analysis, and the fact that it creates such a direct link between the greenhouse gas benefits of of fuel or technology and the amount of incentive it receives. And so, while we do often find technology surprising us in one way or another, in most cases the impacts can be articulated in terms of greenhouse gas impacts, and therefore they're relatively straightforward to integrate into the program. You might need to add a guidance document to talk about how to quantify something, but you don't need to rewrite the program because quantification of greenhouse gas impacts is sort of the foundation of programs like these. So it is a flexible program design that is a lot better than some of the other program designs out there that have been used for alternative fuels or promoting new technologies, which kind of require policymakers to pick the winners and losers, right? To guess which technology is going to be the important one and say, bring me more of that. This program, because a quantitative analysis is baked into everything, and because the proportionality between incentive and greenhouse gas benefit, it's better able than many other greenhouse gas reducing programs to adapt to changing technology. Generally speaking, there haven't been a lot of situations where a novel technology has been promoted and then we realize, whoops, that was a mistake, and had to walk it back. I think the example of the very early biomass-based diesel incentives, primarily coming out of Europe, and the deforestation effects those has, are one of those examples where a policy pushed something to scale and then belatedly realized that that wasn't a good idea. But you can look at alternative fuel policies around the globe, and that lesson has clearly been assimilated and built into the policies to try to prevent those. Not perfectly, obviously. It is a complex problem, and we're still understanding some of the dynamics in there. But in most cases, the need to scale something up to bring it to market means that you don't get people going off half-cocked based on some kind of prospective technology that may look good on paper, but doesn't get out there. These programs, the incentive only flows when the fuel flows, with the exception of the infrastructure capacity credits, which only flow when a very narrow, specifically defined type of infrastructure is built. So it's not like somebody can say, I've got this really cool idea that I can make work in a lab, and then get millions of dollars of money through the program. They have to actually deploy it and have a significant amount of fuel flow through the program before they get the money. And that tends to reduce the chance that you're going to have, something that turns out to be really problematic or useless, receive a lot of incentive.
Thank you for that response. And then maybe one other question that came up in my mind as you were talking. And I think in any new technology or new innovative, sometimes is the life cycle maybe doesn't, in the past hasn't maybe comprehensively analyzed the benefits and maybe some of the cons of a new innovative technology. Is in the life cycle analysis that is kind of, I guess, one of the supporting analysis for this rule. Is it take into consideration also waste, the end of cycle, where you would see the waste for new innovative technology?
Yeah.
Yes, thank you.
So it's a very good question. In most cases, yes. We obviously have to know that the waste is there and be able to quantify it. But where it's there, then yes, it is generally taken into account. The challenge with some life cycle analyses is you might have something that has greenhouse gas benefits, but produces a waste that has a disposal issue or a water pollution issue, and then you come into the question of how many tons of greenhouse gases is a ton of a water pollutant work, and that's a value-based decision to include. There isn't a great sort of silver bullet approach to bring all sorts of very dissimilar environmental impacts into a single framework, which is why you have to have a comprehensive portfolio of policies that say, we're going to have air pollution policies and water pollution policies and labor policies and all these things to prevent harms in other dimensions. And that's why most policies like CTFP basically say you have to follow the rules of your jurisdiction, and there are ways to sort of make sure that any fuel that's receiving incentive is not violating the law or violating environmental policy in the jurisdiction that they come from. So yeah, I don't know if that quite answers your question.
It does. It does. I appreciate that response. And I think maybe I'll segue into maybe Ms. Borchardt or Dr. Rasso is, so given some of the, testimony from Mr. Murphy, as this, these innovative technologies come about, and how that we've talked a little bit, or you've talked a little bit about the guidance documents. What is the, I know this is all hypothetical, but given it's just so rapidly changing, what is really like a reasonable in what you've learned and what you project to be kind of even in the guidance documents, and I think he said like maybe 50 items in there, but that might be 100 in another year or whatever. But how often would even the guidance documents need to be updated?
Oh, I think that's a big question. I think you are spot on with, I'm saying my list of documents, and it's not just guidance, it's SOPs for staff and things like templates for reporting. Is 50 right now, but by the time we get to the effective date of the rule, it might be longer than that. I think that those guidance documents likely will evolve over time, and as we learn and encounter new situations, I don't know that I can necessarily predict the frequency. I can say that many of the guidance documents are based on guidance documents that other states, or at least the topics of the guidance documents, are based on guidance that other states have released. So in that way, we can learn from other programs and start by looking at what their guidance documentation says about specific issues, which might help minimize some of it. But I do think we will definitely encounter new issues that will require us to issue additional guidance documents or revise guidance that's already been put out.
Thank you for that response, Dr. Rasso. And I think going forward, and maybe I heard it in some of the questions by other parties, legal counsels, is so in that process, is it, just for my clarification, is it the intent of the department to be inclusive of parties to provide recommendations, comments, or to those guidance documents as well?
I think this is kind of my answer to your question is maybe a little bit multi-tiered. I think it depends on the guidance document and what change, or if it's a new guidance document, what it makes. I certainly think, as we're seeing here with the number of parties in this hearing and the amount of really substantial evidence that's being presented by those parties, there is a lot of knowledge out there, both by people who have filed it as parties, people who have been part of the advisory committee, might be part of future advisory committees, and as well as just interested members of the public. And I think we are interested in hearing that input from the public and from others and companies. Did that answer your question? Maybe?
It did. Thank you, Dr. Rasso. That's all I have for right now.
Are there any other board member questions for the department panel? Member Garcia.
Thank you. I thought of another quick question. I think there may be one or two landfills that capture methane in New Mexico. Is that right?
I know of at least one, but I can't remember which one it is right now.
Okay. So could they be capturing methane for the credit market then?
If they chose to provide that as a transportation fuel, it could participate in this program.
Okay. Would this rule possibly incentivize other landfills to invest in a system to capture methane? Would it be worth it, do you think?
I think it would be worth it for them. I think many landfills in New Mexico currently flare the methane. As I mentioned in my testimony, there are air quality rules around which landfills are required to control the gases. Usually that means flaring, and I certainly think it would be better if they used it for a productive purpose rather than just flaring it. Whether or not they decide to actually invest in a capture system that can be routed to something useful like transportation probably depends on economic factors.
Right. Okay. Thank you. That's all.
Chair Sweeney.
Thank you, Madam Hearing Officer. I have a question for Mr. Vaughn, and I apologize. I stepped out. I think Member Hunker had made a question about engagement and outreach to pueblos and tribes earlier. I missed a portion of the response, so I apologize if this is a repeat question. But in that engagement, was there a lot of, or in that outreach, was there a lot of engagement by pueblos and tribes, the governments and or their technical staff?
Chair Sweeney and members of the board, we, the department, certainly did an extensive job outreaching to tribes, nations, and pueblos. The reality is, excuse me, that we actually never heard from many of them, whether it was in regard to joining the advisory committee or potentially participating. Part of Ms. Borchardt's response should be, just understood that we just didn't have any engagement.
Thank you for that that response. And I guess how is this rule? I understand the lack of engagement, so I acknowledge that. But how would this rule, I guess, intersect or dovetail into, or does not apply at all to Pueblo tribal nation, our tribal nations lands? Is that an accurate statement?
Generally speaking, state environmental rules don't apply on tribal lands, and we see no reason that this would be different. However, we do think that the rule is flexible enough that if a tribe wanted to participate, we could explore that opportunity with them. One thing we learned from our conversations with other states is that there is only one tribe that is participating in one state program currently, just given all of the other states that have programs.
Thank you for that. And I guess because, here in New Mexico, we are, there's a lot of tribal nation and Pueblo nations footprint. And I understood that even from the record that there's some companies looking to work with some Pueblos and tribes. So that's where the question. So I guess my follow-up is there is flexibility with the rule that could happen.
That's right. We would have to explore that on really a case-by-case basis, dependent on several factors, including their own jurisdictional arrangements, what type of fuel transactions they might have, for example. So it is super specific on a case-by-case basis.
Thank you.
Any other board member questions? No? All right. Ms. Sona, if you would like to do some redirect.
Thank you. Madam Hearing Officer, may I request a brief 5 minutes before I turn to questioning?
Certainly. Let's come back at 3:45. Mr. Maxwell, are you saying you can't hear me? Thanks so much.
Okay. Mr. Vaughn, I'm going to represent to you that the statute 74-1-18, section B, states that when forming the advisory committee, it's composed of stakeholders from in-state and out-of-state producers of transportation fuels, transportation fuel distributors, local governments, utilities, tribal governments, environmental protection groups, environmental justice groups, and other individuals or entities with relevant experience to provide input and periodically review program rules. Does that sound right?
It does.
Okay. And from NMED's perspective, would you force anybody to participate on an advisory committee?
No.
And also,
Mr. Mullenberg.
I'm sorry to interrupt, but normally for redirect, we tie it into some of the cross-examination so we know it's proper redirect. I'm not hearing that here, so I just like to make sure we make it clear to what cross-examination the redirect is going to, so we can tie that in. Thank you.
All right, Ms. Sona, if you're able to do that, that would be great. I understand we also have a time constraint with Dr. Murphy, though, so you may or may not be able to do that with.
yes, Madam Hearing Officer, I can do my best to do that, but also I would point out that I am redirecting on over 2 days worth of testimony. So I would prefer that if someone felt that it's addressing a topic that hasn't been covered, which I would be shocked if that happened, I'd prefer that rather than wasting our time with a foundation, they simply just object and ask me to waive the
All right, just to the extent it's helpful, thank you.
So, Mr. Vaughn, with that question, in the selection process for the advisory committee, there were applicants in a pool of many different applicants of the types that the legislature contemplated. Is that correct? Maybe not, I'm sorry, let me clarify. Maybe not every type, but there was a representation of that list I shared.
That is correct.
Madam Hearing Officer, now that we have Dr. Murphy back with us, may I just turn to him?
Please.
Okay, thank you. Dr. Murphy, thank you so much for being here and sharing your expertise with all of us. You got some questions about research and studies regarding how costs in other state low carbon fuel programs were passed on to customers or to consumers. Can you clarify a little bit about those research and studies?
Sure. So it is, shockingly enough, a very complex topic, and there is no definitive conclusion in the literature. Some of my colleagues at UC Davis actually published a couple studies on this. The general thinking is when there's regulatory costs imposed upon producers of something, in this case would be fuels, they pass those costs on to consumers. The typical assumption is they pass all of it on. The evidence, so it's difficult to parse out the effects from the evidence we have because producers, sellers of anything, and this includes transportation fuels, they get to set the price of their product however they want. Whether or not it relates to costs actually imposed, they set it to maximize their profit as is the right in a free market economy. To fully understand how costs are passed on, we'd need access to proprietary business information, which we don't have. So we attempt to infer it by looking at things like wholesale prices and whether you see price fluctuations that are at the same time as changes in regulatory policy. So within that research, the evidence suggests that probably most of the regulatory costs are passed on. But again, there's a lot of uncertainty there. We don't know how much. The other thing is that in all of the discussions that talk about price impacts from programs like CTFP, there's a number of projections of gasoline cost impacts that are often discussed. Some of them are in some of the exhibits that we have submitted. The process by which you make those estimates, you use essentially the same formula as is in the regulation to figure out how many deficits per gallon, and then assume a credit price, and that's the per gallon cost. The issue is, in many cases, we suspect that the actual compliance costs are lower, because if you're sort of assuming that credit price, you're basically saying we're assuming that the regulated party is just going to go out to the open market and buy the credit at the prevailing price. It's a reasonable assumption, but the program gives a lot of opportunities for them to generate credits through other means, through project-based credits on their own thing. They can buy, alternative fuel production companies, buy EV charging companies, engage in sort of joint ventures or partnerships, do long-term offtake agreements. And kind of the laws of economics say the only reason why somebody would do this is if it was cheaper than going out to the open market and buying at the prevailing price. So we think there's solid evidence that the actual compliance costs are below what the theoretical compliance costs are, the ones that we estimate using that formula. The evidence says so far it's those theoretical compliance costs are what's passed on. So beyond that, it's still an area where more research is needed, and we continue to try to explore.
Thank you, Dr. Murphy. Another issue that we heard about that I believe you're able to be responsive to, and that you shared some testimony on earlier, is to illuminate us on why do other states use a single statewide value for the carbon intensity of petroleum fuels rather than pathway-specific values for each producer or source of petroleum?
Yeah, so from a purely scientific and quantitative basis, you could look at each individual refinery or even each like lot of crude oil that goes into a refinery and get multiple different CI values for the fossil fuels out there. It'd be great for providing myself and my students a lot of employment over the long term. The reason why most states have chosen not to do this is because petroleum is very widely and readily moved around and traded in the U.S. Right, it's transported through pipelines, rail, truck, tankers, etc. And so if you gave the opportunity, and to be clear, there is a meaningful difference in the carbon intensity between different types of fuel and different refineries, depending on how new and efficient the refinery is. Also, some forms of crude oil are lower carbon in that they take less energy to get out of the ground or less energy to refine. So if you gave the opportunity to have each individual sort of source of petroleum get its own carbon intensity pathway, what would likely happen is producers would shift all of the low carbon stuff to go to the states that have programs like CTFP, and then shift all the rest of it to the states that don't. The overall emissions wouldn't change. In fact, they might go slightly up because there might be a little bit more shuffling of crude around, but they would essentially remain unchanged. However, a lot of credits would be generated, or a lot of fewer deficits would be generated under the program. So you'd be getting something that looks on paper like you're actually reducing emissions, but you're not actually reducing emissions. So the way to avoid that is if you use a single statewide average, you update it every year to make sure that the latest production developments are being included. But using a single statewide average means you can't get sort of on paper compliance through crude shuffling or refinery shuffling in that way. In order to give refiners the ability to or an incentive to go above and beyond and to find ways to reduce their emissions beyond industry standards, that's where things like the project-based credits come in. In California, they have refinery investment credits for energy and emissions reducing projects at refineries. They have the innovative crude pathways for things like solar, steam, or renewable energy at fields. So the programs can recognize the efforts that petroleum companies make to reduce their emissions. It's just not done through an individual pathway. This is the approach that works to prevent that shuffling, but still provide the incentive where it's appropriate.
So you just mentioned project credits, Dr. Murphy, and we heard a lot of testimony about project credits. Two-part question for you. How did the other programs treat project credits in the early years? And two, where those opportunities were available, can you share how they had been utilized to the extent that they had been advocated for? In other words, can you share the potential versus the reality?
Sure. In a lot of cases, project credits were added into programs over time. Sometimes it might have been just administrative restrictions, didn't have the time to go and do the work to develop the pathway at the same time when you're standing up an entire program. Sometimes it was just there wasn't a call from the industry to make these sorts of project credits available at the time the program was being stood up, and so they were added in later. And we've absolutely seen in California the example of the infrastructure capacity credits were added in the 2018 rulemaking. And that's a category of project credits. So because these programs, do evolve over time, we've typically seen more and more project credit types get added. For the second question, at least I don't have the numbers for the Oregon Washington programs in my head, but for the California program, at least, the project credits, they have been used, but they've generally been, we'd call them underutilized compared to our assumptions. In most cases, the project credits had, so at least the ones within the petroleum industry, they kind of had a cap on how many credits could be generated. And in most cases, the industry asked for a higher cap. And in basically all of the cases, we came nowhere near the cap. Part of this is because other fuels just offered lower cost opportunities for compliance than to do the innovative crude or the refinery investments. And, again, the market is designed to prioritize the lowest cost routes to compliance. So in California, we've had about 1.5 million credits in the LCFS generated over 15 years, which is a lot, but California also generates about almost 25, 30 million credits a year right now. So it's a lot, but not a lot at the same time. The experience of California might be different in New Mexico because the petroleum industry is, I think, a bigger contribution to the economy here. Also, the geology in California is different, and it certainly might be more amenable to the type of project credits here than it was there. But yeah, generally they've been used, but not heavily used, is I think the short and sweet way to say it.
3 short questions for you left. Does renewable diesel need 3 to 5 years of lead time?
So if you're trying to build a new renewable diesel production facility, yes, right, to go through concept, finance, construction, permitting, et cetera. But if you are a jurisdiction like New Mexico who's adopting a program and wants to make sure it's available to your consumers, no, there's a very large renewable diesel industry in the US right now. We are producing, I believe, around 6 billion gallons of biomass-based diesel. So that's renewable diesel plus biodiesel. The majority of that is renewable diesel. So for near-term needs, especially given that New Mexico is not a terribly large market by state sizes, I would say there's likely to be plenty of renewable diesel. Now, I defer to the economic panel who's done more specific quantitative modeling, can confirm that. But I would be very surprised if fuel providers in New Mexico were unable to identify supply from the national pool.
Thank you, Dr. Murphy. Are avoided methane calculations based on real science? Or in other words, do they have a basis in science?
Yes, the idea that a project, like an anaerobic digester that's producing energy would prevent the release of fugitive methane, that has a strong scientific basis. And the idea that those releases could be additional to what would have otherwise happened also has a strong scientific basis. I know there's been a lot of criticism about the ways that some programs, especially California's program, treats avoided methane credits. I'm certainly not going to say that all of the decisions they make and the full scope of quantification is I think ideal from a scientific standpoint. But conceptually, yes, they have a very strong scientific basis, and the idea that a program like a clean transportation fuel program could provide credit to recognize the emissions benefits they provide aligns with all of the science and life cycle analysis.
Thank you. And last question, Dr. Murphy. You shared with us the past few days a lot of knowledge about academic research, lessons learned from other jurisdictions, the way those jurisdictions operate. Is it fair to say, to kind of recap on all of your testimony, that really this is just the tip of the iceberg for the future of clean transportation fuels?
Yes, more than fair. This is a very complex topic. I've spent the last 10 years of my career, the majority of my time and energy has been focused to researching, modeling, speaking about understanding programs like this. And that's after I got out of grad school. And there's still a ton I don't know, probably more that I don't know than that I do. Luckily, you don't need to have one person understand everything. You have a team, and that's certainly helpful. And you have a program that is flexible to adapt to changing science. Again, because you have this concept of quantifying emissions benefits and aligning incentive with the emissions benefits, and that is a flexible concept that can be extended to a wide variety of fuels and situations. But yeah, there is a ton of complexity here. Like I said earlier, I would love to guide you through that complexity. If you want to go and fall down one of many rabbit holes in this space, please come. I think it's a lot of fun. Hopefully you would agree, but certainly there is a lot of complexity, and there's always going to be this challenge to find out how deep do you want to go and what's the right level of complexity, and where does it become sort of purely academic as opposed to something that matters from a regulatory standpoint or matters to the life of everyday people.
Thank you, Dr. Murphy. Again, we truly appreciate the perspective and views that you've been able to share in this forum. Madam Hearing Officer, may I release this?
Yes, please. Thank you, Dr. Murphy.
Yeah, Chair Sweeney, and thank you so much. I'm happy to be here.
Thank you. I'm going to promise to stay further away from it.
Let's go back to you.
How is this one? To my trusty side bike. Mr. Vaughn, I'm going to turn back to you.
Great.
So just a few more questions for you. We heard a lot of testimony about electric utilities being opt-in fuel under the rule. Do you recall that testimony?
I do.
Is it true that PNM and El Paso Electric have submitted into the record for this hearing letters of support about opting into the program?
Yes, that is true.
Going back to questions, you received many questions about the contents of the exhibits in your testimony. If I told you that your exhibits enclosed with your testimony reached 1,457 pages without your resume and without the spreadsheets, would you believe me?
I would, unfortunately.
Have you memorized all of that?
No, I have not.
But would you say that you are very familiar with the content and commentary that's contained within that body of work?
Yes, that's absolutely true.
In terms of how the department responded to the feedback, to the concerns that are contained to the messages that it heard from the community about the CTFP program. Where would one look to see how the department responded to that?
That's a good question. And I think the right answer is that you will see how the department responded essentially in the multiple iterations of the rule, beginning with the discussion draft rule, continuing on to the petition rule, and including the revised proposed new rule.
And Mr. Vaughn, is it possible to put in writing every aspect of the deliberations, considerations, and thoughts that NMED had on this rule leading up to the petition and to the hearing starting today?
It's truly not.
Respectfully,
but I
Madam
have
Hearing
tried.
Officer.
Wait. Sorry?
Yes, this is Leela Jones. On behalf of Oxy, I'd just like to note an objection that the "is it possible" category of questions was one established at the outset that we would not use in testimony.
I'm sorry, would you repeat that? I was having trouble hearing you.
Absolutely. I just would like to note that at the outset, Madam Hearing Officer, you established that questions beginning with "is it possible" would not be appropriate for testimony.
Right. So she's correct, Ms. Zona. I much prefer questions that ask about likelihood or probability, if you would.
Sure, I'll reframe the question with an intro that I agree. Thank you, Ms. Jones. Mr. Vaughn, would it be reasonable to expect the department to put in writing every aspect of your deliberations, considerations, and thoughts on this rule?
No, it would not be reasonable to do that, but I will note that I have tried to do that in the approximately 1,500 pages that I have submitted into the docket.
Thank you. And last question for the day. What do you hope that the board takes away from your testimony now that you have concluded it?
Madam Hearing Officer,
I do object to that question for lack of foundation as a redirect question. It's just more like an open-ended question about anything.
Yeah, Ms. Zona, I think that sort of thing is more proper for your closing argument, for example.
Well, Madam Hearing Officer, my response to that would be that we have heard 2 days of open-ended questions. These folks had very short time frame to share summaries of their testimony with this board, and that was more than 2 days ago. We first heard from them and their perspective without the framework and the box that they were put into in terms of cross-examination. And so very briefly, I'm just asking Mr. Vaughn to restate in very summary form the important aspects of his testimony. If you'd like me to frame it in that way, I'm happy to do so. But I believe that this panel is entitled to share closing thoughts on their testimony and tie the pieces of the complexities together for the board.
All right. I imagine other parties will want that same opportunity, and that's fine. I am remembering right now that redirect is limited to 10 minutes per witness, and you have about a minute or so left with Mr. Vaughn. So it's probably not unreasonable to allow you to use that 10 minutes as you wish. Go ahead, Mr. Vaughn.
Thank you, Madam Hearing Officer. Chair Sweeney and members of the board, I would just like to reiterate the 3 main points that I did highlight in my opening statement, which is first, that the department did indeed meet all of its notice requirements for this rulemaking. Secondly, that we went well above and beyond what was required, and that is demonstrated in the one PowerPoint slide that I've provided. It is also detailed significantly in my written testimony, and I would refer you there again. And lastly, just that truly all of the input that we received throughout the 17-month rulemaking process has truly informed the various iterations of the rule that, and especially the one that is before you for your consideration now. Thank you for your time.
Thank you, Mr. Vaughn. Ms. Borchert, you were asked a lot of speculative questions and questions with hypotheticals. Would your opinion potentially change your answers to those questions once you've had the opportunity to review an application and see actual facts and circumstances that surround a scenario?
Yes, and I would, in particular, think about the hypotheticals that come to mind about how to apply book and claim both to gaseous and to liquid fuels, maybe also hypotheticals about deferment. Those would be some of the areas in which I got some questions, which, are really depend on the case by case situation and the facts as presented in an application.
Dr. Rasso, for efficiency, how would you answer that same question? And if you need me to repeat it, I'm happy to do so.
No, I think I remember the question. I think my answer is the same as Ms. Borchert's. Throughout the last 2 days, we've had a lot of hypotheticals, and we've tried to couch those answers in the basis of a lot of these decisions being on a case-by-case basis. So any of the answers we've given are kind of specific to that hypothetical and may apply differently on a case-by-case basis as we receive these applications and see what the contents actually are.
Dr. Russell, we'll stay with you for ease of timing. You testified about the statutory requirements in Section 18 of 74-1-18, subsection C6. And I'll represent to you that begins with the words, I quote, "consider similar programs in other jurisdictions," end quote. Do you take the word consider to mean a mandate?
No, I would consider the word consider, sorry. The word consider would not mean a mandate.
Do you interpret that word to mean that NMED is being asked by the legislature to do its homework and find symmetry with other jurisdictions where possible?
Respectfully,
but not a
Madam
mandate
Hearing
to say
Officer.
exactly like other programs?
Respectfully, Madam
Sorry,
Hearing
was there an
Officer,
objection?
Yes, Madam Hearing Officer. This is Leela Jones online again. I just have to object again. Ms. Sona repeatedly insisted that this expert is not able to offer legal conclusions, and yet she's now asking her to interpret a statute.
All right, I'm going to offer the same instruction I've offered numerous times. Please answer in your role as a regulator, if you will, and not as a lawyer.
I'm sorry, I've forgotten the question.
In considering other jurisdictions, was your approach to that to do your homework and think about symmetry, or was your approach to that to be identical to the other jurisdictions?
I would say our approach would be to learn about how other programs offer and decide if take how other states operate as a starting place.
Switching gears, can you confirm that FSE credits apply to all fuels and do not favor one or another because the determination is based on greenhouse gases?
Eligibility for FSE credits is based on the carbon intensity of the fuels, not on what the fuel is specifically.
And so when it comes to FSEs, can you briefly explain, since we have 10 minutes, the different treatment in the rule for FSE registration versus FSE credits?
The point of regulation in these rules is different for different fuels. For fuels where they're commonly used for other purposes, specifically gaseous and electric fuels, the point of regulation in the first fuel reporting entity is the owner of the fuel supplying equipment. And that's also what we mean when we're talking about fuels dispensed in New Mexico. We're talking about mostly compressed natural gas and electricity, and the owners of the equipment that actually supply it as a transportation fuel being the first fuel reporting entity and the regulated party. It's also because the fuel supply equipment is the point of regulation for those fuels, they are required to register in our data management system, where the liquid fuels are not required to register their fuel supply equipment.
Are there any other considerations for FSEs in the rule that are relevant?
Yes. So as I was just speaking about the fuel throughout sections of the fuel reporting entities in the rule, you'll see that the first fuel reporting entity for those gaseous and electric fuels is the fuel supply equipment owner. So that does not necessarily mean that the fuel supply equipment that is registered or that is determining eligibility to be the regulated party is connected in any way to fuel supply equipment credits. Those are separate concepts in these rules.
And as the implementer of these rules, would there be a lot of ambiguity if FSE registration were to disappear from this rule?
Yes.
You spoke quite a bit about alternative fuel pathways and briefly touched on this relationship they have with a 5-year requirement. Can you explain what that relationship is to tie together all your testimony?
Yes. So in section, 202 D5, we specify that approved alternative fuel pathways that are maintained properly and in compliance with these rules are active for a minimum of 5 years within the program. And really what that means is that the department won't ask regulated parties where we've approved a fuel pathway to come in and modify any assumptions or modeling around their pathway, assuming compliance with other parts of the rules for that 5-year period. Following the 5 years, that pathway can remain active as long as the department doesn't make a request of the applicant to come in and change assumptions around their fuel pathway application.
Thank you for the clarification. Is it true that the department has a deep understanding about what issues in this program will be controversial?
I think we have a deep understanding of that. Not only have we reviewed the record of the parties that have entered here, we've also received an enormous amount of input and feedback through the advisory committee and through the input we received on the draft discussion rule. So taking those topics and seeing the topics we've received the most input on gives us a really firm understanding of the controversial issues.
And do you anticipate that the department will do the same elevated engagement that it has done and to allow proper consideration for guidance documents on those issues that you've just identified as understanding as controversial?
Yes, as Mr. Vaughn testified to, we've gone throughout this process above and beyond what's been legally required to us to engage the public and interested parties on these issues, and I anticipate us continuing that as we implement this program.
And lastly, in the opportunity that Mr. Vaughn was offered, do you have a final message or takeaway to share with the board to tie together all of your testimony over the past few days?
I think you members of the board are getting the sense that this is a really complex program, and these rules themselves are very complex and interconnected, and various sections of the rules don't necessarily stand alone. Parts of the rules connect to other parts of the rules in ways that you may not anticipate or you may not see when you just consider one section. Our Bureau has spent hundreds of hours wading through these rules and making sure that those connections make sense. So I'd caution you as you consider proposals by other parties to change parts of the rules to make sure that you understand the ways that they are connected to each other and not leave dangling ends for me as the implementer to try to figure out.
Thank you, Dr. Rasso. Ms. Borchert, back to you for a few brief questions. Do you recall your testimony previously about a Portalis biofuel plant?
I do remember responding to some cross on that, yes.
Okay. Is it correct that not all biofuel used for transportation in New Mexico is produced in New Mexico?
Yes. I don't think there are any ethanol plants currently, and the one in Portales is not up and running yet. So right now, all of the ethanol consumed in New Mexico, to the best of my knowledge, comes from out of state.
Thank you. In the life cycle analysis from well to wheel, you talked about the way that this operates. Can you explain where the energy economy ratio fits in that analysis? Just briefly for us.
Yeah. So the energy economy ratio is a way to capture the input that comes from a fuel and how that's translated into energy in the drivetrain of the vehicle, right? So this is vehicle in the what's called the wheels portion of the well to wheels, and different drivetrains, different vehicle types are much more efficient to move those wheels and get the car down the road. And in particular, an EER 1 is an internal combustion engine. So any EER greater than 1 basically means that the movement of those wheels, the energy it takes to move those wheels, is more efficient than 1.
Thank you. Second to last question. Does NMED believe the role of the advisory committee is to replace department discretion or the board's rulemaking authority?
No, I think they all three have a role to play, but the advisory committee is not meant to replace either the board in making decisions on rules or the department in figuring out how to implement this program.
Thank you. And last question of this panel. Ms. Borchert, do you have anything to share with the board to tie together your testimony over the past few days and what takeaways are most important?
Yeah, I think as has been the subject of a lot of cross, there are a lot of people who have a lot of interested parties who have different takes on what these rules need to include. And I think I would go back to my opening statement, which was that, we, as we have talked about, spend so many hours working on this, really consider the input. And we believe the rules before you really represent a good set of rules that are going to be good for New Mexicans. And so I would also suggest that an earliest potential effective date is important to start getting those greenhouse gas reductions and economic benefits, the jobs, the health benefits you'll hear more about tomorrow now. And also, I hope that you guys have gathered by the depth of our testimony that we are ready to do this, that we know what we're doing and we can do this.
Thank you, Madam Hearing Officer. May we release these 3 witnesses?
Yes, thank you. Thank you, Mr. Vaughn, Ms. Borchert, Dr. Raso. Calling it a day. So thank you all very much.